Division of Privacy and Identity Protection for their leadership in planning this event, in particular Elisa Gilson, Jim Trilling, and Jared Ho. Before I begin, I want to note that my remarks today reflect my own views and not necessarily the views of the Commission or any other commissioner. I'd like to use my time today to speak briefly about 3 aspects of the FTC's approach to consumer privacy that I see or hope to see evolving: the role of notice and choice, the integration of competition and consumer protection concerns, and FTC authority and resources. Let's begin with the limitations of notice and consent, or as it sometimes seems, I didn't really know, and I had no choice but to agree. The notice and consent framework began as a sensible application of basic consumer protection principles to privacy. Tell consumers what you're doing with their data and secure their consent. But in order for a notice and consent regime to be effective, both elements must be meaningful. Notice must give consumers information they need and can understand, and consumers must have a choice about whether to consent. I am concerned that today, when it comes to our digital lives, neither notice nor consent is meaningful. By now, we've all heard the estimate that it would take 76 working days to read all of the privacy policies one encounters in a year. It's no wonder then that a more recent study from 2016 demonstrated that 98% of potential users of a social media site had no problem clicking "I agree" to privacy policies and terms of service that disclosed sharing with the NSA and paying for the service by signing away your firstborn child. As an oldest child and as a parent, I have to assume that this was a close reading failure and not an indictment of the strong and spirited dispositions of so many firstborn. Another study showed that a majority of Americans believe that when a company merely posts a privacy policy, it means that the company does not share user data. These studies and myriad others simply validate what we all already know. Clicking through these policies presents little value to consumers. They are often long and confusing, and even when they try to be more succinct, their sheer number places an insurmountable burden on consumers trying to navigate the marketplace. I'm not saying that privacy policies don't have value. They do. At their best, they force companies to think through how they are treating consumer data and publicize that promise. This is beneficial to the company, to researchers, and to law enforcement, but it provides little immediate benefit to the consumer trying to access the services she needs while maintaining some control over her privacy. Furthermore, as we've heard several commenters note over the last 2 days, we cannot consider click-through consent to present a meaningful choice. The choice is illusory because even if a consumer could read and understand the notice, she often has no choice but to consent in order to reach a digital service that has become necessary for participation in contemporary society. And as the panelists discussed yesterday, even where it appears consumers have given valid consent, that agreement might be a product of manipulative dark patterns. And I just pause to note that in a fortuitous coincidence of timing, 2 senators introduced a bill to deal exactly with this issue of dark patterns just yesterday. It is easy to decry the limitations of the notice and consent framework and far harder to reach a conclusion about what should replace it. We could adopt the GDPR approach of trying to cure the problem by presenting more useful information to consumers more plainly. The jury is still out on its effectiveness, but no doubt improved notice and consent over specific practices could and should be debated as part of a U.S. privacy framework going forward. We could also look to the CCPA's requirements to present consumers with meaningful opt-out choices, particularly over the sale and transfer of their data. Or we could impose more concrete purpose limitations, where data can only be used by a company for the purpose for which it was provided. The rich debate on this topic this morning and yesterday demonstrates that there are a number of paths to improve the current framework. In the midst of this debate, I want to put my thumb on the scale for solutions that do not place all or even most of the burden on the consumer. It is the job of the entity collecting, transferring, or using the data to accurately and fairly assess consumers' expectations about how their data will be used and to meet those expectations. If the company misuses the data, law enforcement needs to be able to step in to hold companies accountable. I also want to advocate for solutions that deliver consumers meaningful choices, which require policyholders to consider both consumer protection and competition concerns. The FTC is lucky to have both competition experts and consumer protection experts working together in one agency. Many of these hearings have underscored how intertwined traditional consumer protection concerns are with competition concerns, particularly in the area of data privacy. The limitations of the notice and consent framework is one such area that raises both concerns. We'd all rather live in a world where digital platforms compete for users on metrics such as privacy. But today, consumers often need to cede all control over their data to participate in or use certain services that have become critical to their everyday lives. They don't have the option to turn to a competing, more privacy-protective service. This dearth of real choice is a privacy problem, but it is also a competition problem. Lack of choice is not the only area where privacy and competition concerns collide. The increased risk to consumers arising from consolidated pools of data also raise competition and privacy concerns. In today's economy, when two firms combine, they are also almost certainly marrying large amounts of personal data as well. Does the emerging firm have the ability to manage that data or related technology safely? Did consumers expect when they share data with company A that it might one day be combined with data shared with company B? And will the emerging firm use the combined data sets in a manner that is consistent with consumers' original expectations? And perhaps most obviously, developing a national privacy framework necessitates balancing competition and privacy goals. We must take care that in attempting to secure increased protection for consumer data privacy, we don't inadvertently further entrench incumbents or otherwise hinder competition and choice. This is a concern that has been expressed frequently by those who oppose new privacy laws. I agree it is a concern, but I do not agree that it means we should stick with the status quo, which provides limited protection of privacy and limited competition. As these hearings demonstrate, the FTC is already moving toward more blended debates and dialogues about these issues. I am particularly optimistic that this trajectory will continue through the Chairman's new technology task force, which will leverage both our antitrust and privacy expertise. Finally, I want to conclude today by spending a minute on the FTC's authority and resources devoted to consumer privacy. One of the questions posed to ground this hearing is, what should the role of the Commission be in the privacy area? The FTC serves many roles: business counselor, consumer educator, researcher, and advocate, but our most critical role is that of enforcer. Thoughtful policy debates and balanced legislation will be to no avail if the resulting statutory framework does not provide for serious enforcement mechanisms and resources to incentivize compliance. Today, the FTC's privacy enforcement centers around a handful of sector-specific rules: FCRA, COPPA safeguards, and our Section 5 Unfairness and Deception Authority. Our rules allow us to protect children's information online and to help ensure that non-bank financial institutions and the CRAs are protecting consumer data, but it leaves some gaping holes. Large categories of personal data are not covered by our rules: what we share on social media, what we share with many retailers, including our largest online retailers, and what we share with apps and devices, even when we share personal health or relationship information. And this is just the data we intend to share. When our data is harvested and collected without our knowledge or expectation, in most cases, our rules don't cover those practices either. Even when we do have specific rules in place, that does not guarantee that we have penalty authority. For COPPA and FCRA we do, but we have no penalty authority under the safeguards rule. In order to protect consumer data and privacy beyond the narrow fields covered by our rules, we must rely on our Section 5 Unfairness and Deception Authority. The FTC has been nimble and aggressive in its attempts to use this 100-year-old statute to police today's technology-driven marketplace with many successes. But we face real limitations proceeding under Section 5. We cannot seek monetary penalties for data and security privacy violations in the first instance generally, and quantifying consumer injury in terms of dollar amounts is challenging. Moreover, without specific statutes or rules defining practices in this area, both courts and companies have been left with questions about whether particular behavior is prohibited. Because of these limitations, the majority of the Commission supports the enactment of a comprehensive federal privacy law that does three things in terms of enforcement. First, empowers the FTC to seek significant monetary penalties for privacy violations in the first instance. Second, gives the FTC APA rulemaking authority to allow us to craft flexible rules that reflect stakeholder input and can be periodically updated to keep up with technological developments. And finally, repeals the common carrier and nonprofit exemptions under the FTC Act to ensure that more of the entities entrusted with consumer data are held to a consistent standard. But the single biggest change that would help the FTC in its role as enforcer of data privacy laws right now would be an increase in our resources. We currently have about 40 full-time and fully dedicated employees devoted to privacy and data security. We have 5 full-time technologists, most of whom serve all of our consumer protection missions, not just data privacy. The UK Information Commissioner's Office, by contrast, has 500 employees. The Irish Data Protection Commissioner has over 100. We have a much larger jurisdiction, both subject matter and geographically, and blunter tools than our European colleagues, yet we have a fraction of the personnel. The FTC's current annual budget is $306 million, and like most organizations, our greatest expense is also our greatest resource, staff. Approximately 2/3 of our current budget is allocated to pay and benefits for staff. If the FTC received an additional $50 million in ongoing annual funding, we could hire approximately 160 more staffers. An additional $75 million would enable us to bring on board 260 more staff members. That would, incidentally, put us around the staffing level we had in 1982, before the internet, and still well below the levels in the late 1970s. With increased staff, the FTC would be able to devote more resources to enforcing our existing rules and any future privacy rules. We would also be able to expand the number of staff dedicated to conducting compliance reviews of our privacy and data security orders. We would be able to do more than just react to the worst behaviors in the marketplace. Additional staffing could be used to generate additional research, or original research, conduct 6B studies of industry, and of course, focus on strategic targeting, investigation, and case generation. The threats to privacy that consumers face in the marketplace are growing and grow ever more complicated. Our budget has not kept pace with these developments, and our future as an effective enforcer in the area of data privacy hinges on an expansion of both our authority and our resources. I thank you again for letting me participate in today's hearing, and I look forward to hearing more on this topic from our experts this afternoon discussing their views on the adequacy of the FTC's toolkit. Thank you very much.
Hi, welcome. James, welcome to this afternoon's panel on accountability. I'm James Cooper, the Deputy Director for Economic Analysis in the Bureau of Consumer Protection. And moderating along with me is Andrew Stivers, who is the Deputy Director for Consumer Protection in the Bureau of Economics. So we're sort of like doppelgangers. I can't believe we're together on the same stage and not annihilating each other. But anyway, the symmetry is eerie. Anyway, so we're here today to talk about the concept of accountability. We have a great panel, and we have limited time. I'll just give very, very brief introductions. Their full bios are in our in our program. So right to Andrew's left is Marty Abrams. Marty is Mr. Accountability. He's really, no one has been involved in this or thought about this as long as he has. Currently, he's the Executive Director and Chief Strategist for the Information Accountability Foundation. Next to Marty is Dan Caprio. Dan is the co-founder and executive chairman of the Providence Group. He's an expert in transatlantic data transfer, and he used to be an advisor to Commissioner Urson Swindle here at the FTC. Next to Dan is Mike Hensey. Mike is a partner at the Hensey Law Firm, PLLC, and prior to that, he spent 18 years at Microsoft, where he was the Chief Privacy Counsel. Going down next to Mike is Corinne McSherry. She is the legal director at the Electronic Frontier Foundation. Ari Ezra Waldman is next to Corinne. He is a professor of law and the director of the Innovation Center for Law and Technology at New York Law School. And then finally, at far end, is Karen Zakaria. She is the Chief Privacy Officer at Verizon. Again, so we have A great panel. What I wanted to do to kind of set the stage is ask Marty to tell us a little bit about accountability. Again, there's probably no one who's more associated with the notion or studied this longer than, been involved in it longer than Marty. And so what I was hoping is if you could just briefly tell us about accountability. How does it differ from other approaches? You know, what does it really mean to a layperson?
So first of all, thank you to Andrew and to James and to the Federal Trade Commission for letting me be here today. Marcus was here yesterday. He did a very good job of laying out accountability, and so maybe he is Mr. Accountability and I'm just the guy who's been doing this for 30 years. When I think about accountability, why is accountability important to individuals? It's because the highest and best use of data is creation of new knowledge. And the fact is it's new knowledge that drives the innovation which has distinguished the digital marketplace in the United States from digital marketplaces every place else. And by the digital marketplace, I don't mean digital advertising. While that's part of it, it's not really it. The digital marketplace is smart cars. The digital marketplace is personalized medicine. The digital marketplace is all of the things that we do with knowledge and data that we were not able to do so before. And the concept of digital knowledge and the knowledge creation drives what we refer to as inferred data. And inferred data is new data that comes out of the insights that come from discovery using data. And I can't think of another way of making sure that that's done in a legal, fair, and just way other than through the concepts of accountability and how accountability works. Think of the fact that accountability, as we have defined it since 2009, is really about organizations being responsible with what they do with data and then being answerable for being responsible. And both sides of that equation, both being responsible and answerable, are incredibly important. There was something called the Global Accountability Dialogue that met first in 2009, and it was the Global Accountability Dialogue that defined the modern concepts of accountability, which were laid out first by the OECD guidelines in 1980. And there are 5 essential elements of accountability. The first is that organizations have to self-assert that they're accountable, have the policies to truly be accountable. Those policies need to be linked to external criteria. As my friends at the Federal Trade Commission know, if you self-assert, you're then subject to Section 5 of the FTC Act. So no one should say accountability is a self-regulatory system. It's actually not a self-regulatory system. It's a system of organizational governance that then has oversight that goes behind it. The second essential element is that you have the mechanisms to put those policies into place. And those mechanisms include the things that we traditionally think about, such as education for staff, training, procedures, et cetera. But it also includes the concept of doing a risk assessment, and a risk assessment on what your use of data means to all of the stakeholders who are impacted by that data. Not just me as an individual, but all individuals, society as a whole. So organizations need to be able to do that risk assessment. The third essential element is that organizations now need to have an oversight process that goes along with all of the mechanisms that go into place to make sure that those mechanisms actually work. Part of that oversight process is oversight over those risk assessments to make sure that they're done with competency and done with integrity. So the fact is that the internal oversight process is separate from the process of doing privacy by design, for example. The fourth is that the word knowledge and the understanding of the public are important, so you need to have a means for individual participation in the process. So it requires transparency, it requires access and correction where that's appropriate for the process. It requires that you listen to the voice of the people. It means that in some cases you do research on individual concepts and ideas. In some cases it means you bring in experts, but the fact is that you have to have the voice of the people. And the fifth is, and this is one of the most important, is you stand ready to demonstrate your accountable process. And by being able to demonstrate that accountable process, you're open for the type of criticism that allows you to know that what indeed you're doing with data is acceptable, it's legal, fair, and just. Now, there are a number of companies in this room that truly have embraced this concept of accountability. This morning, when it was mentioned privacy by design, organizations that do privacy by design are actually fulfilling one of the requirements of accountability. But if you were to say, are most companies at this point, have they embraced accountability? Do they even understand accountability? In our work, we find that most organizations have some of the elements of accountability, but for accountability to be fully effective, there needs to be a comprehensive program that has all of the pieces of accountability and understanding of how those pieces link together. As Marcus mentioned yesterday, the General Data Protection Regulation in Europe actually requires accountability, and within the law it has all the elements of accountability, but it never draws those pieces together. And until companies and organizations understand what it means to be an accountable organization and understand how they're going to report to the public on how they are indeed being accountable, then we'll always have this gap. So let me quit there and say that really what we need to do as part of improving the process is having a description for organizations of what it truly means to be an accountable organization.
Thanks, and I just want to just follow up just a tiny bit. So just again, and this is coming from someone as thinking as an economist, I hadn't really thought about accountability as a term of art in privacy as it is. Does accountability, is the teeth behind accountability ultimately some legal authority? And what does the notion of accountability add to, leaving aside, say, the GDPR, which explicitly requires it, but do you think about Section 5 or you think about the other regulatory regimes throughout the world? What does the accountability add that perhaps a legal would be missing in current legal regimes?
So the ICO, which is the privacy regulator in Europe, had a meeting with 1,000 businesses on Monday of this week on what she is looking for in terms of privacy compliance over the next year. And she said to those folks, she says, if something goes wrong and we come into your house as part of an investigation of an enforcement action, the first thing we're going to ask you is for you to show us your comprehensive privacy program to establish accountability. For her, the first step in investigation is saying, let me see your program, let me understand your program. Spain amended their privacy law in 2011 to give the regulator the ability to reduce fines for organizations that were accountable if they had an oops and had something goes wrong and it's not a systematic mistake. So the fact is your own consent orders here at the FTC require organizations to be accountable. So you require that for organizations that have had an oops, but not generally for the market. So the fact is that accountability is about taking organizations to account. Part of accountability, I believe, is ex-ante processes, and maybe if we have time, we can discuss that later. But it's really about the requirement that organizations understanding what they're doing with data, understand the risks associated with it, mitigate those risks for other parties that are involved, and having the ability to describe that.
Thanks. Andrew?
So, as an economist, I'm interested in sort of how the market interacts with this particular concept. You know, at the FTC, we often look at the world as sort of trying to make markets work. And I wonder, Ari, if you can address or give us some thoughts on, what is it about this particular set of responsibilities that Marty laid out that, isn't part of or maybe it is part of the standard sort of accountability that consumer-facing firms, always have to their customers. If they don't offer a product that, consumers want at the price that they're willing to pay, then they're held accountable. So can you help us understand what else is going on here, if anything?
Sure. So thank you, first of all, for inviting me to participate, and thanks for everyone for coming. Thanks to the FTC and to our moderators, James and Andrew. I'm going to talk for a few minutes about why the market is incapable of adequately allowing consumers to hold companies accountable. And there are really three main reasons why. And after going through those reasons, I'm going to suggest a little bit about what we might do in order to address some of those gaps. The first reason are information asymmetries. Efficient and fair markets require awareness and information on both sides. Consumers need enough information to know if a salesperson is offering them a lemon or a bad product, or a massive data collection scheme is hiding behind a friendly interface. Instead, the digital marketplaces that we have are characterized by enormous asymmetries of information. Technology companies know every single detail about us. Their ability to marshal large data sets to identify unique and unexpected correlations with in that data allows them to identify what they think we like or what they think we want to buy and tailor our online experiences. On the other hand, as Frank Pasquale has noted, we have very little background knowledge about how all of that works, what they know, how platforms use and gather, manipulate, and analyze our data. We don't know the correlations between our behavior on those websites and the ability of these companies to create virtual personas of us. Therefore, we don't really know what we're giving up in exchange for the convenience that the digital marketplaces or social networks provide. A second barrier to market solutions to this problem are psychological barriers to rational choice. Even if we did read those long and legalese privacy policies that so many people here today and yesterday have correctly dismissed as completely garbage, we couldn't adequately translate what we learn into a rational decision, as any neoclassical model would require. We are all susceptible to what psychologists like George Ainsley and David Laibson have called hyperbolic discounting, or time-inconsistent preferences. That's our inability to adequately weigh the potential of future risks and rewards against the reality of current rewards. We are also terrible at what Dan Gilbert calls affective forecasting, or assessing our feelings about what will happen in the future relative to today. So if we can't adequately assess the potential of future risks as against the reality of current rewards, either convenience or some minimal reward of having your name or a cookie, having your name remembered or a cookie dropped on your computer, how are we going to be able to translate that into rational decisions about our privacy? That important point leads to the third reason why there's no market for privacy preferences and why the market can't solve these problems. In fact, the market is designed out by the technology companies themselves. We operate in online environments that are designed for us and, in fact, are designed to manipulate our autonomy and maximize our data disclosure. Design is a powerful force that constrains our behavior in a space, and you can't make fully rational choices when the environment doesn't let you. As Woody Hartzog has stated in his latest book, Privacy's Blueprint, the realities of technology at scale, and I'm quoting here, mean that the services we use must necessarily be built in a way that constrains our choices. Technology companies have their own agenda. And that is to collect as much data as possible. And as they are the ones in charge of designing the environments in which we interact with them and with other people, it will always be designed in ways that facilitates their business success, not our needs or human flourishing. Design nudges us to behave in certain ways. They make us feel guilty when we don't engage, and leverages our innate desire for popular feedback, for that little thumbs up, and takes advantage of our attraction to bright, shiny buttons that says, click here and move on. The point is not that design is bad. The point is that when technology companies have control over design, we, who are their subjects, are not in a position to make fully autonomous, independent, free choices, even if we read, understood, and were able to operationalize the privacy policies that they offer us. Given this, technology companies know that there's little risk of users not choosing to share their data. Given the current legal regime, little risk that companies will be held accountable when users finally realize what happened and then voice their displeasure at being manipulated, as so many stories over the last couple of years have shown. So if there is no market if the market can't solve these problems, what does real accountability look like? My concern with the approach of the five accountability elements that we've just seen is that it doesn't always hold up on the ground. My research focuses on how technology companies implement privacy laws on the ground, and a lot of times the responsibility for privacy compliance is, despite having, at least on paper, adequate systems, structures in place, audits and offices and so forth, all of the things that would meet all of the 5 requirements of the accountability regime, a lot of those responsibilities are outsourced to privacy technology vendors, to engineers who are trying to create, who are there to create easily codable or easy to use solutions, supposedly easy to use solutions that are, as a result, undermining the promises of privacy law. So what would a regime with real accountability look like? And I'll just list a few and then end here and we can move on. I think some of the things that have been said here over the last couple of days and in the Commissioner's brief speech before this panel are correct. A legislative approach must shift the burden of protecting privacy from the user, who can't protect her privacy, to the company, who is in a much better position to. A new legislative approach should deploy fiduciary obligations on technology companies, as Jock Balkin, Neil Richards, who is here, and Woody Hartzog and myself and others have argued, and permit private rights of action when data is misused. One of the problems that we've noted is that the FTC is understaffed. We need to up the FTC staff, but to exclusively rely on FTC enforcement when we take away private rights of action is going to be unreasonable. A legislative approach should incorporate purpose limitation and data minimization, which actually are some of the requirements of fiduciaries anyway. A new legislative approach would require technologies to be designed from the ground up in ways that chooses the most privacy effective design, most effective design possible with the most privacy protective design. The legislative agenda could also track the requirements of Sarbanes-Oxley and make technology companies' executives directly responsible for signing off on privacy assessments and hold them liable if they mislead the public or fail to incorporate privacy protections from the ground up. The only way we're going to make a company that has contrary business interests to privacy protections to take our privacy seriously is to hold them accountable. A regulatory approach should double down on design, and the FTC needs to put its muscle behind a consumer protection agenda that recognizes the manipulative power of design, as Woody Hartzog has argued. Based on my own research, the FTC needs to look into making sure that its audits are real and enforced and followed up, as opposed to permissive assessments that don't allow for any real feedback. A regulatory approach would consider executive public statements as part of a company's commitments to consumers, especially since highly publicized statements by highly publicized executives, maybe in front of Congress, for example, are far more likely to become part of consumers' decision-making processes than something hidden in a privacy policy. The FTC, as the Commissioner noted, needs fining power and easier rulemaking powers to enforce legislation to ensure that companies' feet will be held to the fire.
Ari, I'm sorry to interrupt you. We do have a number of other panelists. If you could wrap up and we can move on. I apologize, but.
And these are just a few of the steps that we need to put real accountability.
Thank you.
Yeah.
Thanks.
All right. Yeah, and so thanks, Ari, and hopefully we'll be able to get back into that. But again, we have short time and several panelists. But I want to move to Karen next, and as we think about accountability, we've heard from Marty about what it is, what his key tenets are. We've heard from Ari about how the marketplace may not be and may not provide consumers with the level of privacy they want. There are reasons to think that that may not be the case. So we see, as Marty mentioned, accountability is specifically a part of the GDPR, as lots of activities kicking around on Capitol Hill, thinking about, I forget who it was yesterday, one of the panelists said, you know, we've had our privacy moment this year, the U.S. has had it, and lots of legislations kicking around on Capitol Hill. What do you think the role of accountability should be in any sort of U.S. legal regime?
Thanks for the question, and thanks for having me here today. I think in the U.S. we really are at a crossroads and we have two choices. One is we can continue along the path that we have where we have some state laws that are governing data breach and privacy. We have some federal sector-specific laws. We have some self-regulatory regimes. And then we have accountability programs in companies. Or we can say the time is now, we should have a federal privacy law. And I've been lucky enough to be in this job at Verizon for 8 years, and the entire time that I've been at Verizon, we've been advocating for a comprehensive privacy law. And many of the elements of what we think should be in the law really are intertwined with the accountability principles. I've sometimes described what should be in a federal privacy law as the equivalent to a really complicated maze. And there are different ways to get out of it, but there's not just one path. So I'm not going to sit here today and say privacy law needs to have the following 162 provisions in it. But what I'd like to do is spend a little bit of time talking about some of the overarching principles, and in particular how those interrelate with the accountability framework that we're talking about. So as I said, it should be a federal law. It should be comprehensive. It should apply to all players in the ecosystem with one federal regulator enforcing it, which would be the FTC. The law needs to be flexible. And why do I say that? We want to make sure that this law can apply to the technologies of the future, both the ones that we already know about, whether it's 5G, something that Verizon's rolling out, Internet of Things, or new services and products that none of us in this room could even dream of today. We also want to make sure that the law will take into account new approaches to protect privacy, and it's not so prescriptive that if we have new methods, companies can't adopt to those. So if a law included some of the things that Marty mentioned earlier, things like training requirements or risk assessments, that's exactly what the law should say. Companies should do risk assessments, but it shouldn't then specify how it does those risk assessments. Other accountability elements that should be in a law would include things like transparency and choice. Companies should be required to be transparent with their customers and to tell them the types of information that they're collecting and how they're using it. Companies should be required to give appropriate choices. A law should also include accountability elements like data security and data breach. Now, the federal privacy law wouldn't have to include those if there was going to be a separate data breach and security law. So, it could be one law, it could be two laws, but we should have a federal law that talks about those issues. A law should have safe harbor programs. Why is this important? We're dealing with some really complicated issues, and sometimes the better way to work out how companies should act and what best practices are is to let companies come together, companies across industries, company and advocates, but figure out what those best practices should be, include them in a safe harbor program that meets or exceeds the law, and then companies who follow the safe harbor program are deemed to be in compliance, similar to what we have today in the COPPA world. And then last but not least, I want to talk about oversight, another important element of any accountability program. Marty talked about making sure that companies have their internal governance structure in place. That is certainly an important element. And then we definitely need some kind of external oversight. And what we would recommend, as I said in the beginning, is that the FTC be the federal enforcer. It should have additional civil penalty rights subject to caps, and also that state AGs should be able to enforce it. And I think I want to conclude by talking a little bit about incentives. Companies like mine have every incentive to do the right thing by our customers. We know that customers are only going to buy our products if they trust us, and so from the very top of the house, the C-suite is very, very focused on customer trust and on privacy issues. And but I do think that one of the reasons why it's really important to have a federal privacy law is to make sure that all companies are incented to do the right thing.
Thanks,
Thank you.
Karen. So, Corinne, just to kind of follow up on, Karen's talking about what a federal privacy law and how accountability would work in something like that. I want to drill down a little bit onto the notion of transparency, and if there are any regulatory approaches you think that, how important is transparency to making firms accountable, and are there any regulatory approaches to transparency you think make sense?
Sure. So I think we could probably all agree that transparency is kind of job one. You can't have accountability until you have transparency, but I think it's important actually to drill down on what that means. It seems to me that at a minimum, transparency means you've got a window into the actual practices of a company, what's actually doing as opposed to what it says in its policy, and is there actually a match between those things? But you need a little bit more than that. You need to have transparency into the ecosystem within which that company functions, because we all know that the data doesn't just stay in one place. It moves all around and is shared across many different companies depending on the industry. So you need to have a window into that ecosystem. And the third, and these are all interrelated, you need to have a window into the actual nature of the risk. So if I'm a consumer, it's very difficult for me to assess. This is part of the sort of choice problem. It's very hard for me to even know what I'm choosing and what my risks are and what the risks are for my data. So, if I go to Target and I use my Target card or whatever, I know that they know what I buy. Do I know what they're doing with that information? Do I know who they're sharing it with? Do I know what they can infer from that information? Like they can infer that I'm pregnant or that I'm not or whatever, I'm alcoholic, whatever it is. Am I thinking about all that? Probably not, and it's probably going to be hard for me to do that, but I should at least have an opportunity to have a window into it. Or someone that I delegate to handle that for me, because I agree, I think a lot of people are saying users shouldn't be in charge of all of this by themselves. But there's a lot of things I don't know, and more importantly, I don't even know to ask. And I think Commissioner Slaughter made reference to this earlier, to the study that I think actually was in my home state of California, that a majority of Californians believed that if your website had a privacy policy, that meant they didn't share your data. So just the existence of a privacy policy somehow meant this entirely different thing. And so they didn't ask further questions because they didn't think they had to. And they're busy people and have other things to do. I don't think we can blame them for not being perfect privacy lawyers. And again, it's even more difficult for a consumer to assess risk. So for example, I might know a little bit about de-minimization, and I might know a little bit about anonymization, and I might think, oh, my data will be only shared anonymously, and that will be fine. Do I know anything about re-identification? Probably not, right? And as a consumer, I'm not in a very good position to assess that risk. But the company that's collecting my data probably is. And so when we talk about companies being transparent and talk about their responsibilities, I think that's part of the responsibility because they're best placed to know that. So anyway, if accountability is supposed to mean anything, it seems to me that's all of that information has to be available in clear language to me as a consumer or to the expert that I delegate. So what can the FTC do about this? This is one of the things that I was asked to address. And I think we're starting to overlap, so I'm going to be quick because I want us to have a time for a conversation. But right now, even before any additional work, it seems to me that FTC settlements could require much more rigorous audits and assessments that don't rely on management statements, but instead by careful investigation of actual practices in context. I think that assessments and audits should be made publicly available more than they are. There may need to be redactions, but that way, privacy scholars, for example, people who actually do police privacy and help keep consumers informed can do their work in a much more effective way. And I think that privacy policies are terrible in many, many ways, but I do think that part of what they could include would be clear language about the actual risks to consumers so that they know what they're getting into. But I would suggest that we need to go far further than that. So there should be some additional mechanisms that go beyond the FTC. So I would like to see really robust whistleblower protections so that people within companies who have a window into what's going on feel more comfortable and safer letting the FTC or other regulators know or other lawmakers know. Because really, it's the people on the inside that really understand how the data is being handled, and it's not always easy for someone from the outside to do that. I do think, I think I've heard a couple people suggest this, I do think we should have a private right of action. So for privacy harms, and that relates to transparency, because one of the things that happens when you have a class action lawsuit is you have discovery, and you have investigations, and you have lawyers who are empowered and interested in really digging into what the company is doing. And we don't have to dig into the preemption debate too deeply, but I do think that for now, we really want a situation where there's lots of different regulators, like attorneys general, state attorneys general, who are empowered to do the kinds of investigations that we need to have real transparency and real accountability. Now, the final thing I would just note, though, about transparency in particular is that, I'll just state the obvious. Transparency is great, but this is low-hanging fruit. Right? Transparency is just your starter point. And all the knowledge in the world isn't really that useful to me if there's nothing I can do about it. So that's sort of, we have to keep building in, and that's why I think flexible rules and flexible procedures are very, very important, but they need to be meaningful. They need to be real sticks and not just carrots.
Okay. Would anyone else like to jump in on the transparency issue, or any things that Karen put on the table as well, as far as what we may want to see in legislation as far as transparency or accountability goes?
So there is a concept that was brought up this morning that's a very important concept, and that is the concept of setting parameters for what are legitimate uses of data. And the fact is that part of establishing an accountability program is actually as part of your assessment saying that you're within that range of legitimate uses. For those who know the GDPR, we're talking about the specification of legal basis to process. We find similar in the Brazilian legislation that recently passed. We would find similar in Argentina when they passed their new legislation. But that is by specifying that, we still give flexibility to the organization, but we give some parameters around what is an appropriate use of data.
Yeah, I agree with almost everything that Corinne said. I think the point about audits is incredibly important. The FTC says in almost all of its consent decrees that there'll be an audit and it'll be every 2 years after, under the life of the consent decree. But right now, they're not even real audits. They're assessments that are based in large part on executive statements in regards to the questions that are asked. And I've read them. I've read these redacted ones as part of my research, and they quite literally say things like the requirement is that you are complying with the 2011, with Section 4B of the 2000 whatever consent decree, and then it says, please see Exhibit I, and Exhibit I is simply an executive statement that they are complying with it, with Section 4 whatever of the consent decree. And that's not an audit. That is just an attempt to create a smokescreen with no substance behind it. So if the FTC is really committed to making its enforcement powers all that it can be, that doesn't even require legislation. The FTC should just could simply first take seriously the powers that it does have.
So transparency is I think in this context so far has been discussed as a very positive thing. One could take the privacy policies that various folks already pointed out some of the issues with that, Commissioner Slaughter in her opening remarks. But I'm not sure that I'm quite ready to declare it dead. So Mike, I was wondering if you could, you have, I think, written about some of the benefits of a privacy policy. I wonder if you can give us some of your thoughts on why maybe they're not completely worthless.
Yeah, I would go even farther than that.
All right, excellent.
I have written on that. I wrote a paper a couple of years ago called In Defense of the Long Privacy Policy. And Privacy policies are maligned and criticized all the time. People criticize them for being too long. There was this famous study about 10 years ago that said that if consumers had to read every privacy policy that they encountered over the course of a year, it would take 244 hours. We heard this morning that privacy policies have only increased in the last several years in terms of length. A lot of this is tied into that general criticism about the inadequacy of notice and choice as kind of the foundation for privacy regulation. Lots of criticism that many privacy policies, not the ones I've written, of course, are confusing and opaque. I think you referred to them as complete garbage. And certainly there's some truth to that. You can find examples of very bad privacy policies out there, very bad privacy statements. And as a result, consumers generally don't read them. I think that's undebatable. Most consumers don't read every privacy policy they come across. But nevertheless, I think they're very, very useful in creating accountability for a couple of reasons. One, particularly if we can get away from this pressure on companies to make privacy policies short and simple. I think that's a really misguided pressure to put on companies, because if they are detailed, if companies are forced to disclose or encouraged or incentivized to disclose detailed information about what they're doing, the mere process of creating that document creates accountability. It forces companies to do data mapping, to do privacy reviews, to understand what data they're collecting. And the mere putting in place those processes inside of an organization can be incredibly useful. Similar to other mechanisms that we're seeing in privacy laws, like under the GDPR, we've got the Article 30 record-keeping requirements and the requirements to create data protection impact assessments for high-risk data processing scenarios. Just that act of reviewing and documenting these practices can be incredibly useful. And the fact with a privacy statement that you have to post it publicly. It creates that second step of pausing and saying, is this a story I want to tell? And if it's not, it encourages companies to adopt new mitigation strategies, to maybe improve their privacy practices in other ways so that they have a more complete positive story that they can put out there. And the fact that consumers rarely read these things, I think, is not a fatal flaw necessarily. There are other entities out there that can act as proxies for the consumers and put real pressure on companies more so than an individual consumer can. And these are regulators and policymakers that might read them, academics and researchers, privacy activists, journalists, investors are increasingly reading these for startups that might be acquired or that they want to invest in, and plaintiffs' lawyers obviously are reading these as well. And all of those actors have an ability to put pressure on companies to improve their privacy practices. So I think that creates absolutely real accountability. But this only works if privacy statements are detailed. And you look at a lot of the other proposals that are out there to make privacy statements shorter or simpler, whether they're for nutrition label approaches or icons or other approaches to privacy statement. I think those all fall short in this goal of creating accountability. Those who are pushing them have this idea that privacy can be reduced to these binary choices or very simplified facts, and that's just not the reality of most environments where privacy is an issue. If we're looking at sort of a binary choice, is data shared with a third party? Well, that's not very interesting to me. What's interesting is what types of parties is it shared with, for what purposes, and what protections are in place around that. Every time companies are sharing data with each other, at least every time I've been involved with, there's a contract there, and those contracts sets out privacy and security obligations and restrictions on data use. And those are the facts that are interesting. Those are the facts that create sort of the real, whether there's a risk here or whether it's not, whether it's inappropriate or whether it's beneficial or whether it's harmful. And so if we try to simplify and shorten these things, it's just not going to create that kind of accountability. It's not going to create that kind of transparency that fosters accountability. So I'll stop there. So
I would be shocked if folks didn't have some comments that they wanted to add to that. So let's open it up to.
Yeah, I respect Mike and his work quite a bit, but I just think that's wrong. I mean, certainly there is a value to stating your policies. Just as Corinne said, transparency is important, but it's not the be-all and end-all. I would say that we ask too much of transparency and privacy policies. We expect that they provide us with the ability to make rational choices. There's nothing that suggests that we can't have one privacy policy that's long and detailed for regulators and other tools, not necessarily a privacy policy, maybe it's visceral reactions or other things, that actually do tell users what's going on in a more acceptable or in a more psychologically driven way.
And to be clear, Ari, I'm not claiming that a long privacy policy is the be-all and end-all. And I absolutely agree with you that there are better ways and other ways to supplement that are more focused on the consumer. Just-in-time notices, contextual notices, design factors. I think all of those are super important, but unless you also have the very detailed privacy statement, I think you don't create that level of accountability, because the contextual stuff is fantastic, but if you ever want to go back and figure out what the whole story is, it's often very hard to recreate that context and find that information again. So again, the privacy notice may have another benefit of like being the one place you can go back to. Say when you agreed or you went through a sign-up process, you didn't have a particular sensitivity, and then something changed in your life and you did. It's hard to go back and go through that sign-up process again to figure out those choices you made or what you were thinking when you decided to use that product. But having a long, detailed privacy statement will have that information there. And I should have also pointed out, I meant to point out that, having it long is no excuse for crappy design, right? Things like layering and things like writing clearly, avoiding legalese, all that stuff is important. People should be able to find the information that's relevant to them when they need that information. And I think a privacy statement can foster that, but it's not the whole answer, and it shouldn't be done by itself.
Well, I certainly respect that, and I agree. I think that the long privacy policy has been used by companies, however, to absolve themselves of responsibility. So my concern would only be with, I don't think we need to get rid of them. Fine, they're there. But my concern would be perpetuating the ability of technology companies to use them. Of course, in the ideal world, they would be a whole lot better, as you say. But perpetuating them as a false operation where companies are allowed to get away with everything because they know that no one's actually going to read that narrative.
So this isn't about the length, this is about what is in there. And I just want to briefly say that I actually think going forward, when we use information beyond people's common understanding, we should actually be talking about our values and judge us on our values, and that should be part of what we're judged on. So I'm actually seeing longer, but that isn't about what's transparent to easily understand by the individual. It's part of the description of what you should be judged on. I'll just be quiet from there. And
would you like to add something, Karen?
Yeah, I think to some extent, everybody is right here. I think we need both. I think we need the long policies for some of the reasons that Mike talked about, and Ari, for some of the reasons that you talked about. We also have to figure out ways to give our customers the information that's the most important to them. The problem is that's sometimes challenging. Mike gave the example about sharing, right? I think all companies share information with third parties, right? You have to do that for all sorts of reasons. And so figuring out how to explain the aspects of that customers are most interested in is really what companies like mine have to figure out. And you're never going to be able to do it for all of your customers and to satisfy each of their needs, because some customers are going to have different views on it. But at least if you can figure out what's most important to most of them and try to highlight that, I think that should be our goal.
Thanks. Anyone else, Corinne?
So this might be a place to interject something that I think is kind of complicated here. I think that a lot of times when we're talking about privacy in this context, we're thinking of really straightforward sort of consumer privacy, someone collecting information about what I buy. And we lose sight a little bit of that privacy means a lot of different kinds of things that overlap. And I wonder if as we think about privacy policies, one of the things I think where they fail is they're not particularly good at grasping that and communicating that. And so just to give an example, so I might have a privacy policy that tells me, your data, this is the kind of data that we're going to collect about you, and here's how we handle it. And I say, okay, but I'm just thinking of that, and the company assumes I'm just thinking of that in terms of advertising and marketing. And maybe I don't realize that this database can also be targeted by law enforcement. Or maybe I don't realize that this database can also, if I'm in, I don't know, a messy divorce, that there might be a subpoena for my information in connection with that. So I'm just sort of throwing a wrench in the whole thing, but I do think that as we're thinking about privacy and accountability, one of the things that we have to be put on the table is understanding that privacy means a lot of different things, and we don't always unpack that as we're trying to think about consumer risk, for example. So I just want to put that on the table.
And that's actually a good segue to want to move to Dan, who's been a shrinking violet on this panel, strangely, but get you involved in draw you out a little bit, and draw you into this conversation. And speaking of this is something you've thought about in the context of risk management and informational injury. So, the idea that privacy means different things to different people. We talked a little bit about this, was discussed on the panel I moderated yesterday and some other panels, this notion of informational injuries, that there are certainly some things we care more about than others, and that's baked into at least the U.S. law with children and health and so on, versus broad commercial data security under Section 5. Can you talk a little bit about how accountability mechanisms work in this context and with respect to risk management?
Sure, and thanks, James and Andrew, and thanks to the FTC for including me. As Marty mentioned at the beginning, and Marcus Hyder mentioned yesterday very eloquently, there are many accountability mechanisms to manage risk, and there seems to be a consensus on the broad contours of privacy accountability, the acceptance of responsibility for privacy protections, the ability to demonstrate that privacy promises are being met, effective governance that ensures an organization has the proper focus and resources to meet its privacy promises, and of course, compliance with law and regulation. There's also a recognition that the use of risk management, that those approaches provide a sound foundation for developing accountability. Privacy professionals are now well-versed in many of these risk management concepts through the important work done by the National Institute of Standards and Technology, NIST, the National Telecommunications and Information Administration, NTIA, the Office of Management and Budget, and of course the FTC. Some of the more well-known risk management concepts include organizational governance structures, such as the appointment of a chief privacy officer, the development of policies and procedures, the application and monitoring of privacy controls, and workforce training and education. These risk management tools are necessary for an accountable privacy compliance program, whether it's internally created to meet privacy promises, made to consumers, or through government regulation, but they are not sufficient for a mature risk management program. So why are they not sufficient? Too many risk management programs generally, and privacy risk management programs in particular, do not employ the tools necessary for thinking about emerging risk. That is, risks that may not be recognized today, but may well become a reality in the foreseeable future. Why is it then that risk management programs tend to be limited to current risk, especially compliance risk? Well, the simple answer is because thinking about the future is hard. There are tools, however, that can help and should be part of any risk management program for accountability. These tools have been tested in national security, corporate strategic planning, and product development. They include scenario development and analysis, wargaming, and design thinking. Are these tools a crystal ball in the future? No. But they do help organizations overcome biases to imagine the possible futures in which they must operate, and they help break down communication barriers between organizational functions and silos in order to plan for emerging risk effectively. So I think accountability for privacy management program to be fully accountable, it must not only ensure that it meets current compliance requirements, but it also must take into account the potential future impacts it has on privacy and society.
So there have been a number of really interesting questions that folks have brought up, and unfortunately we don't have all afternoon, though maybe we'll take a little extra time. Nobody minds? Probably won't work out. But there are a couple questions that I would like to raise. One is one that I think is kind of lurking behind all this, but we haven't really addressed it directly, and I would like to get the panelists' input on this. You know, we've been talking about the responsibilities, additional responsibilities that we think that firms should take on here. I wonder if the panelists could address questions of cost, and down, as an economist, I have to bring this up, of course, it's in my contract. I wonder if the panelists could bring up, what are the potential downsides of this sort of regime? Are there none? Is this really sort of a everybody wins sort of situation? And if it is, kind of why isn't it more widespread? You know, why are we having this conversation about the requirement of these, of accountability, and just sort of saying, well, you know, it's all good, people are doing it. So I'll open this up to everyone. But, Marty?
So bright line rules that say you can't use data because we're afraid of the outcomes that come from that data, and we see some of that in the GDPR, is much more costly because that restricts our ability to create new concepts, new ideas, new insights, new ways of creating value. So yes, having the operational elements of accountability in your organization has expense. It is much cheaper than giving up discovery of new ideas, new concepts, new knowledge that will then drive innovation. So this is much cheaper than bright line rules.
Dan?
So a couple of thoughts, Andrew. And this is sort of thinking, you know, at the senior corporate level. I think it's important to, I mean, for the FTC and for companies to think of data as an asset, number one. Number two, when you think about accountability, as I mentioned, that good risk management is not just about being compliant. That accountability tends to be a very good mechanism for looking backward, but we need to think of ways to creatively to think of it as we go forward. And then three, I think, you know, we need to figure out ways or examine ways to incentivize organizations to mitigate the risk of harmful uses or exposure to personal data. And we had a whole panel yesterday on de-identification. So I think that's a fruitful area.
I would say, of course, there's costs. It takes time and personnel and resources to put these kinds of measures in place. But it pales in comparison, not just to the opportunity costs that Marty talked about, but to the costs of a privacy screw-up. I mean, once something goes wrong, the cost of dealing with that reactively is orders of magnitude greater than the proactive approach.
The other kind of cost I'd like to mention is when laws aren't clear, or when we get interpretations of laws sort of too late, it becomes very challenging for companies to implement them, or they go down one path, or they spend a lot of time churning about one path, and then there has to be a switch. So some kind of clarity is important, and interpretations in enough time to be able to implement.
Here are the kind of arguments that Mr. Abrams made earlier about now costs, well, some of the costs are in generation of new ideas and innovation. I think this whole conversation yesterday began with a presentation about how there were costs to innovation from privacy restrictions. There are tons of studies that demonstrate that that's not the case, that privacy regulation does not stifle innovation. There's a new paper by Catherine Strandberg coming out. There are papers each year from behavioral economists that show that there is no binary choice between privacy rules and innovation and generative ideas. So I would caution us from being taking that as an assumption, because even in the neoclassical model, what regulation is supposed to do is guide innovation, guide new ideas and new opportunities, and guide opportunities to fill demand based on the values that society highlights.
So I'm not trying to suggest that you'd forget privacy, but anybody who's working with trying to make research work in the European context today knows what I mean about the lack of ability to free up data for data-driven research because the rules are just designed not competently. So you can cite the research, I can cite the real on-the-ground results in Europe today.
In a couple minutes we have left, I wanted to we get a good question from the audience, and this the idea here is that the notion of accountability, we've heard a lot about sort of internal processes, but does accountability in any way, and this touches on, I think, something that Ari discussed about, it's related to the idea of maybe an information fiduciary or a fiduciary relationship. Does accountability embrace the notion that you should safeguard data, use it in ways that doesn't cause harm, and how do we think about what those harms would be? Anyone?
I think it's important to not see, for regulators and the law to create this idea in our consciousness that data is not merely an asset. Data is a responsibility. To suggest that data is just an asset means that we can buy and sell it, we can do pretty much whatever we want subject to small limitations. But given the way and the importance in which data flows have to our interactions with each other today and basic human flourishing, having data, using it, wanting to make money off the amount of data that you have and wanting to make use of the data that you collect is a responsibility. And the way to recognize that is to impose fiduciary-like obligations on companies that ensure that you're not using that data in a way that at a minimum, ensures you're not using it in ways that harm customers or consumers so you can benefit yourself.
Dan, do you want to jump in?
So part of this reminds me of the conversation we were having yesterday about GDPR and the 4% fine for global turnover. And it was said that, that's gotten the attention of the C-suite. Well, I would agree with that, but I would argue to this point, in the wrong sense. So what we're trying to do when we're talking about valuing data is getting companies, and in terms of risk management, getting companies to think about privacy strategically. And so the idea of a lot of prescription and fiduciary responsibilities, that we run the risk of having the same problem that we have with GDPR, which is this becomes operational control, and it becomes a compliance cost, and it goes way down in the bowels of the organization, and the company just sees it as a cost. So I think we've really got to flip it and see it as see data and privacy as a value.
So,
I'll let you have a real quick, but we have triple zeros. So
okay, just a final thing. I think the idea of information fiduciaries has a lot of value to it, as long as we don't assume that that's going to cover all the bases. We're going to need more than that concept, it seems to me, to ultimately protect consumer privacy. What I like about it is I do think it encourages thinking about information and thinking about data as something more than an asset, but rather something that's actually important information about a person that they may care deeply about having shared or not shared.
Well, thanks. It's going to have to be the last word. Join me in thanking our panelists for this great discussion, and we'll be back in 15 minutes for Is the FTC's Current Toolkit Adequate? Part 1.
here. Souvenirs for my friends.
I heard you've got a new, sorry.
Hello, sir. How are you, buddy?
Hi, everyone. We're actually ready to get started. People could please take their seats. Good afternoon. My name is Jim Trilling. I am an attorney in the Division of Privacy and Identity Protection, and I will be co-moderating this panel along with Manisha Mithal, the director of DPIP. Our panelists today are Christine Bannon, Consumer Protection Counsel at the Electronic Privacy Information Center, Mark Groman, a principal at Groman Consulting Group and a former chief privacy officer of the FTC, Jane Horvath, Senior Director of Global Privacy at Apple, Stu Inglis, Chairman of Venable, Peter Swire, the Elizabeth and Tommy Holder Chair of Law and Ethics at the Georgia Tech Scheller College of Business, and we may be joined by John Leibowitz while the panel is in progress. With that, Manisha's going to kick things off.
Okay. Good afternoon, everyone, and welcome to our panel. So as we've kind of been preparing for this panel, we're going to divide up our discussion into kind of 4 parts. The first part, we're going to talk about how we measure success at the FTC. Second, we're going to talk about gaps in our existing authority under Section 5 of the FTC Act. Third, we're going to talk about gaps in our remedies. And finally, we'll talk about additional tools and resources that the FTC may need. So we'll try to roughly divide that up into equal parts. And so if somebody has something on a later discussion, if you could save that comment for later. So first, the first question I wanted to throw out to the group is what should be the FTC's role in the privacy area? What would define successful FTC intervention, and how can the FTC measure success? And as you're answering this question, I just want to note one thing that I think we've heard over the last 2 days. We've heard a lot of panelists and public discussion around the fact that a lot of these questions that we're asking over these 2 days involve similar questions to what we were asking 10 years ago or even 20 years ago, and there doesn't seem to be any more consensus today than there was then. So is the FTC doing something wrong? Is there something more we should be doing to either develop that consensus or to protect consumers' privacy generally? And I'd like to throw out that question in the first instance to Mark Groman.
Great. Well, it's a pleasure to be here, and that's a really interesting way to tee it up by looking back at the workshops, because I want to focus on that as well. There's no easy way to do metrics or measure success in the area of privacy. I've been trying to do that for 15 years to various bosses. I've had privacy in every title I've ever had. And so, looking to things like the FTC Privacy Report, where you report on things like number of cases filed, consent agreements, dollars gotten from civil penalties. That is, maybe it demonstrates that you're using taxpayer dollars efficiently or effectively, but that is not a metric for success in privacy. And so, tying to what you just said about the workshops, and I don't mean this to be flip, because I'm dead serious, is that how I would measure success is that will you have hearings in 5 years, and the conversation is completely different. And if that occurs in 5 years, then I think that we can evaluate it and look at success. And what do I mean by that? What should be different? This will shock you, but let's have some fun. We're not talking about privacy, because that word does not capture half of what we discussed over the past 2 days. It is far too narrow. We are also no longer discussing what is personally identifiable data or not. That debate's over, and we're talking about what are the impacts of data on people, whether one person or a group, but we're done with this discussion and fight over what is PII. We're not using innovation as this thing to balance against privacy. It is so overused. Innovation means change. That's what it means. And so what we want is responsible innovation, not innovation at all cost. On the tech front, what I'd like to see is more presentations on deeper issues in technology, and I'd like to see it done by the FTC staff, meaning that you are at a level of technical competency that you are doing the presentations and not bringing in others to do it. We're talking about data more granularly like others did today. We're recognizing that data, whether it's provided by individuals or observed or inferred, have different levels of sensitivity, and we're taking that on and we're doing it head on. And then just quickly on the notice and choice, we'll have success if in 5 years the U.S. Chamber of Commerce is caught up to the rest of the world and not long still pushing for a notice and choice bill.
Okay, so a lot to unpack there. I would invite all the panelists to chime in and respond to anything that Mark said, but in addition to that, I'm going to just throw out another question, picking up off one of the things Mark said. So Mark said that we've sometimes measured by the number of cases we've brought or the civil penalties we've obtained, or and we could try to measure in concrete numbers, which may not be the best level of success or best measure of success. So I guess the follow-up question would be, how can the FTC get feedback on whether it's using its tools appropriately to sufficiently protect consumers? And let me just kind of add a question on to that, which is that some people claim, or we've seen kind of public statements about some people saying that even though the FTC has been using its tools in this space, we consistently see privacy failures. So does this indicate a lack of FTC success? So I throw that open to anybody on the panel or anybody to react to Mark's comments. Okay, Stu.
See if I know how to work this. Is it on? It's just on already. Okay. Well, thank you for having me participate on this great panel. And I thought, as always, I see a lot of value in Mark's comments. I would just add a couple of points. I think the FTC's role in privacy has been a huge success. Could always be improved like anything. And I would measure that on two fronts. How companies treat data and how far they've come based on the FTC's enforcement. The FTC actually took a statute that had nothing to do with privacy and has created a whole series of cases and law and effective responsibilities of serious companies and serious professionals. And to do that in an age of such unbelievable change and innovation, I think is really, really hard. And I would argue there's probably not an analogous example in the development of kind of the society we live in. So the other way I would measure it is continuing to be at the center of this dialogue, showing the leadership through multiple commissions on a bipartisan basis. Look at this meeting today. There's a full room here, and there are hundreds, if not thousands, of people around the country, hello to all of you, watching all of this. There's a bunch of folks back in my office watching this, and I think you've shown great leadership in keeping this debate and this important societal value front and center. So I would compliment you. On Mark's point, I would agree. It's time to evolve and continue to evolve the debate. We're calling, in the groups that I'm working with, Privacy for America, we're calling for a new paradigm to really tackle some of the new and next generation thinking along a lot of the things Mark mentioned.
Okay, great. And I think you'll get a chance to talk about that in a second. Christine, did you want to add something?
Yeah, I'll say that I think we should measure the FTC's effectiveness through the enforcement of orders. I think when particularly Facebook and Google consent orders were announced, it was really seen as a sea change, and people were really expecting a dramatic change in how the company's privacy programs operated. But we've only seen, in the years since then, more privacy violations by the companies, and I think any upcoming action that the FTC takes to enforce the consent order against Facebook based on the Cambridge Analytica story will be a litmus test for effectiveness.
Okay, and just picking up on that point, I think that kind of gets to the question I was asking about, is the existence of privacy failures in the marketplace some sort of a yardstick by which the FTC should measure success, and if so, how? Anybody want to comment on that? Jane?
I would just say that you could also look at a measure of privacy successes in the marketplace. I think that over the last 10 to 15 years, you've seen an evolution towards business models that are looking not at how much data can we collect, but at how can we first protect our customers' privacy while we innovate and build new products. And I would say the FTC's work, the workshops, and the ongoing papers, et cetera, have given really good guidance to that. So I think that is one of the successes, as opposed to looking and saying, oh, there's a market failure, the FTC is obviously not successful. Look at all the companies that are successful building privacy into their business models.
Okay, thank you. So I think one kind of something that goes hand in hand with how you measure FTC success is the question of what should the FTC's goals be. And there was a lot of discussion yesterday about what the goals of privacy protection should be. And I just thought, let me just ask for a show of hands on the panel. I jotted down 4 things that people said. That one goal is preventing harm. Another goal is improving transparency and consumer choice. A third goal is avoiding surprises / I wrote this down, / complying with consumers' expectations. And fourth is kind of promoting innovation and the benefits of technology and competition. Now, you can raise your hand for more than one of those, but I'm just very curious. So how many people on the panel believe that preventing harms is a primary goal of FTC intervention? Okay, consensus. Okay. How many people believe improving transparency and control is a measure of success?
Yeah.
This is motherhood and apple pie, by the way.
Right.
Okay. What about avoiding surprises and comporting with consumer expectations? Okay. And finally, promoting innovation and benefits of the marketplace. Okay, all right, so we have consensus. I think our work is done. Okay, but does anybody want to unpack any of those issues, talk about some of the relative importance of each of those vis-a-vis each other? Yeah, Mark.
Well, one thing that, going off of what Jane said, and I don't know how we exactly measure whether it has worked or not, but we want good policy to drive incentives for industry and commercial actors to engage in best practices, and we also want to see incentives for new technologies. And so again, what would I like to see in 5 years? I would like to see a small army of companies that have new technologies and privacy-enhancing technologies. There is not the incentive to do that now. And so I think that goes to the effectiveness of the FTC and others. I do not think the incentives today are adequate to push companies to invest a lot of money in privacy-enhancing technologies. One of the benefits or positive outcomes of GDPR, in my view, is that it has driven investment in that kind of technology. There are problems with it, but that is a good measure of success. Are companies incentivized to do best practices or deterred from negative outcomes?
I think it's curious that all the panelists raised their hands when I asked if one of the goals should be improving transparency and consumer control. I feel like for the last 10 years, and including today, the idea of notice and choice has been quite vilified. So how do you reconcile those two things? Consensus, there should be transparency and control, but there shouldn't be notice and choice. I'm not quite sure how those terms are different. Peter, can I?
It's necessary but not sufficient.
Okay.
You have to have notice, or else the company doesn't know what it's doing and the consumers don't know what it's doing. There's choice at various points, but to say that that's all of privacy is missing many, many other issues.
Okay. Anybody else? Let me just, again, unpack one of the goals I mentioned, which was kind of avoiding surprises and comporting with consumer expectations. What do you say to those who say, well, there's a lot of surprises in the marketplace that are actually good? There are certain things that consumers didn't realize they wanted, but they actually do want it, and that's what the marketplace is providing. And any reactions to that, or any rejoinder to that criticism? Yeah, Mark.
I think there's a lot of consensus that context matters, and so we want to make sure that is baked into an analysis of risk. And that consumers do have reasonable expectations, and that uses of data that are outside those expectations in some kind of framework need to be treated differently.
But how do you, so again, this was brought up on a panel yesterday, how do you measure consumer expectations?
I think we have to look at risk. So I think that focusing on conversations on like what is sensitive or not, right, that's sort of a small element of a larger discussion that we ought to be having, which is when you have a kind of business practice that is surprise outside of context, what risks are we presenting to individuals? And putting individuals at the center of that risk analysis, I think helps drive us to a good outcome.
Okay, I want to turn it over to the next part of the discussion, but one thing I wanted to ask the panelists to think about as we loop back to this in a further discussion is the idea of if we were thinking about crafting legislation, we hear that it's important to kind of, not surprise consumers and comply with consumers' expectations, but is that something that would be possible to legislate? Is it something that we should be recommending that Congress be considering? So I'm not going to ask for answers for that right now, but I tee that up, and let's pick up on that thread later if we could. So why don't we, Jim, do you want to do the?
Sure. So we're going to move on to discuss gaps in the FTC's authority. The FTC has general authority under Section 5 of the FTC Act to prevent unfair or deceptive acts or practices. Stu mentioned in his opening comments that the FTC Act itself could be characterized as not textually having anything to do with privacy. What are the limits of unfairness and deception as the primary tools for FTC privacy enforcement? And are those limitations keeping the FTC from protecting consumer privacy adequately? So I'm actually going to ask Peter to take the first response to that.
Yeah, thanks very much, and it's great to be here as part of the continuing FTC efforts to do the workshops and think this through. I played the role of old man in these rooms sometimes. I wrote a book on EU-US privacy 21 years ago and was chief counselor for privacy beginning 20 years ago. So I have some historical perspective on FTC successes, and I'm going to highlight 3 legal developments that make some of the earlier FTC victories not as impactful today. So things that were authorities and effective but don't work as well today. And one's deception, second's consent decrees, and third is Article 3 standing. So on deception, the FTC had a huge win in the late 90s getting people to post privacy policies. And you can see the statistics, and companies posted them. And when the companies posted them, the companies at that point didn't really know very well what their data flows were, and they made lots of mistakes. So there was ripe fruit for enforcement actions in the early days under deception. Lots of good consent decrees got written. But over time, 2 things happened. One is the companies learned what their data flows are, so they stopped overpromising. And the second thing is the companies hired lawyers who had more and more practice in making sure they wouldn't get caught for the company. And so deception as a tool doesn't work as well because companies aren't overpromising as much as they did before. A second problem is in consent decrees, which have had all sorts of success. And Dan Sullivan, Woody Hartzog have their articles about the common law of consent decrees, and it was very hopeful about what these would produce. But, and it has produced big 20-year agreements. But I think after Wyndham and LabMD, my sense among litigators is if they have a bet the company kind of case, that they're going to fight the FTC, that the easy days of consent decrees are not going to be there, and the FTC is going to find it harder to stretch the limits of its authority. Companies are going to push back. And the FTC has finite resources, so that the FTC is going to have to be a little bit careful pushing the limits of its unfairness policy. And I just said deception doesn't work as well. And the third one, again, briefly, is Article 3 standing, which maybe is less familiar here. A lot of people who follow the class action cases see that a lot of federal judges have been saying that for data breaches and things like that, there's not really Article 3 standing, that there isn't the right kind of injury in fact. But in the Spokio case, there was some of that same kind of litigation that came back to affect the FTC, and I had my quotes. So the Supreme Court said that Article 3 standing requires a concrete injury, even in the context of a statutory violation. So if the company flat out violated a law, that isn't enough to make sure they're standing even for the FTC. And it also said that Congress is well positioned to identify intangible harms that do meet minimum Article 3 requirements. So if you're thinking about what Congress might do, one thing Congress might do is define intangible harms so that there would be Article 3 standing. And the second thing is, to the extent you want individuals to bring suits, which some people want and some people hate, the states don't have Article 3 limits. States can bring intangible harm suits, but a lot of federal judges think in the federal courts those intangible suits will fail. So there may be in the preemption debates reason to keep some state causes of action if you want those intangible claims at all, because the federal court standing rules restrict not just the FTC on statutory violations, but private plaintiffs when they think they're injured. So a lot of the things that were there probably won't be as effective going forward, and that's a reason to rethink what the FTC's powers are going to be.
Thanks, Peter. So let's continue along the lines of the same topic. So what are actionable privacy injuries under the unfairness prong of Section 5 of the FTC Act? And are there gaps?
Unfairness under deception?
Under unfairness.
Under privacy, unfairness under privacy, I'm going to let a former chairman explain when that wins. It's a pretty hard claim, I think. People have had a hard time in some settings, many settings, finding an unfairness claim.
Well, certainly in our common law of privacy that we enforce through settlements, we use the unfairness prong reasonably effectively. Now, you might say that it doesn't reach some of that we didn't use it with respect to monetary remedies. Those are, of course, much harder when you're dealing with harms like a breach of privacy. But I tend to think that and I don't think I'm in disagreement with you, because I think you raised actually very important points. But I tend to think between the FTC's unfairness authority, its deception authority, and its and really the unscrupulous business conduct line of cases that we used in at least one matter, the Intel matter, a few years ago, that you can reach a lot of the conduct. I think one of the issues that I think policymakers and the Commission, I don't want to jump ahead, is sort of too far, is facing today is sort of whether the remedies are strong enough, I think, and then two is whether you need ex ante rules rather than just ex post enforcement as a way of protecting consumers and giving them more control over their data.
Right. And we'll come back to remedies. So some panelists, let me talk about a specific type of injury. Some panelists have suggested that emotional injury is or should be a basis for bringing unfairness cases. Do people have reactions to that as to whether under existing law the FTC can base unfairness claims on emotional injuries, and whether the FTC should be able to base unfairness claims on emotional injuries? Mark?
Well, I think that the bigger question which you're teeing up is simply that, or to answer the other question, is that there are enormous gaps with unfairness, and there are an enormous number of practices that are not addressed by unfairness and can't be. And in fact, that's the way the law works. I mean, it's sometimes hard to explain that to people, but not every bad thing can be addressed by the FTC or FTC Act. And that is definitely true in privacy, where even as an attorney here, you're often trying to shoehorn factual allegations into the three prongs of unfairness. And one of the most difficult ones is the injury prong, where it could be a small injury to lots of people or a big harm to some people. But we need to figure that out. And I think just saying, is it emotional injury? I think that, begs the question of what are we talking about? How significant could it be? Up to, serious anxiety or demonstrable. The concept in and of itself doesn't bother me. We have to get down to more details and to assess whether it's substantial in a context, which goes to the bigger question. We legislators need to sort this out and figure out what are the full scope of adverse consequences from data use that we want the FTC or some agency to address.
Do others want to weigh in on the ability of the FTC to reach injuries like emotional injuries under the unfairness prong of the FTC Act? Peter?
I think that's part of why I was raising Spokio with the federal court skepticism of injuries unless they meet all these words like concrete and particularized. And then in unfairness, it's even a higher burden many times because it's not just a flat-out statutory violation, which was claimed in Spokio, but you have to meet those prongs of the unfairness test, which was designed to be relatively strict in the 1980s so that the FTC wouldn't get out of control. That's why it was written in the 1980s. So I think unfairness, let me put it this way, I think it would be fair to say there's litigation risk for the FTC if you go up with a straight emotional injury claim and nothing beyond that.
But in a privacy case, so let's take a case where there is a camera in a home and the company turns on the camera and is filming or observing you inside your home, right?
And indeed, we had that case in about
Right.
2011.
So, I mean, what is the harm? It's not financial. It's not identity theft. It's some form of what? Embarrassment or emotional harm or a feeling that my home has been, right, invaded because this camera went on and shouldn't have. There seems to be uniform agreement on the commission that that's a good case. What is the injury? Isn't that a kind of emotional injury? Cameras went on in my home and I didn't expect them to.
So that's a good segue into discussion of the FTC's Vizio case, in which the commission alleged that the collection and sharing of granular individual or household viewing data without knowledge or consent was unfair. Do people have thoughts on the FTC's pursuit of unfairness in that case? The issue of viewing data in particular, and how you would categorize the harm that may be at issue in that type of undisclosed collection and sharing.
I'd just like to make a more general comment that I think that harms are going to be evolving as more and more things go on, happen in the digital realm, that there will be an evolving understanding of what is harm in that realm. So as I think that if we look back historically, the court may not have found concrete harm, but as more and more is taking place in that realm, there may be more of a willingness to see a concrete harm in an emotional scenario.
So in that particular case, then Acting Chairman Olhausen wrote a concurrence in which she called on the commission to examine more rigorously what constitutes substantial injury in the context of information about consumers. The commission subsequently had an informational injury workshop in December of 2017. Informational injury has also been a topic in this current series of hearings on competition and consumer protection. Should the commission take additional steps to examine informational injury? And if so, what types of steps should the commission take?
There's silence on that, but I come back to this point that if Congress were to pass a statute and were to say that certain things counted as injury, that you're in a stronger position in litigation on standing going forward. That's something Congress could do to help.
Yeah, I would add, I think you could actually, the Congress or through rules, if you had the authority to do it, the FTC had the authority to do it, could define bad practices in a way that the statute would lay out where you wouldn't need to even get into a debate about the harm. You could enumerate the types of practices that often have been the rulings in consent decrees. And then as to harm, I think, and I agree with Peter's comment on that, I think you could enumerate things beyond economic harm that are harm. Emotional one gets challenging, but it's not impossible. And in fact, there are legions of court cases in other contexts that define what constitutes emotional harm. One of the things that we've been looking at in detail is to look in other areas of common law, for example, around defamation, where you could assess what are the criteria and what is it about defamatory remarks that should be considered about harm. How did courts find that? And is there something that can be clearly articulated beyond economic harm that would be built into a statute?
Let's shift gears and talk a little bit about deception. So the FTC deception statement says that the materiality of express statements should be presumed. Is this true if the statement is buried in a privacy policy? Does the presumption of materiality make sense when it comes to statements about privacy practices? Or is there something different about privacy policies and other statements about privacy practices?
I'll say,
Christine?
I think that the statements made in privacy policies have to be considered material. I know Epic and many others today criticize privacy policies, but if we can't even hold companies to the policies that they're publishing to their consumers, then I'm not sure what purpose those are serving. So.
Does anyone disagree with that? Does anyone believe that the presumption of materiality should not apply to an express statement about privacy practices? What are examples of privacy violations that don't violate the FTC Act but should be illegal? And want to sort of feed into the question that over the last 2 days we've heard discussion about price discrimination as a possible issue that stakeholders connect to the collection and use of data. We've also heard reference to dark patterns. We've heard reference to differential pricing. Are any of those violations, or are there other violations that there may be questions about the applicability of Section 5 of the FTC Act that you would identify as gaps that policymakers should think about filling? Peter?
I guess I could. So one is the whole area of algorithmic transparency and discrimination. That's not really a deception claim. You could argue that it would be an unfairness claim, though the triggers for what's unfair there is not simple to define. And so a huge amount of the privacy writing, if you go to privacy law scholars, is on sort of the uses of big data and machine learning and such. So how FTC is going to get there with unfairness and deception, I think, is something that I haven't seen clearly done. And then I think there's more and more public discussion about the intersection with antitrust and privacy. Price discrimination among economists, there's lots of times when they think it's efficient, there's sometimes when they think it's not efficient. So just saying price discrimination is not nearly enough to establish an antitrust violation. But in Europe, at least, there's a lot of discussion about dominant platforms and dominant players. Once you get to 30, 40, 50% of a market, the rules around contracting start to change under European competition law. The US hasn't gone there previously, but there's going to be, I think, a tremendous amount of discussions about what the right way to do that is. And so I would guess that's an area that will get a lot more attention.
So I think that two areas to think about. These are complicated, and difficult to articulate. But one is when practices impact behavior. And so it's not that there's a clear injury, but let's say when Facebook uses algorithms to change an emotion or change the things I perceive or alter choices in a way that is outside the scope of my expectations. Not in every case that presents a problem, but it could in many cases, but particularly when it's very large, and I don't know that that would fit within the FTC Act. And then what I would call chilling effect, which is not in this case government, but I would hope that we all want consumers to reach out and use the internet for the amazing things it's there for, which is to find all kinds of information. And I don't want people to not reach out for it and get data because they'll be viewed at, there's a consequence that they don't know about for very particularly sensitive areas.
Thank you. So with that, I think we're going to move into the remedies portion of the discussion.
Actually, Stu, did you have your hand up? Did you want to say something on that before we move on?
No, go ahead.
Okay.
Keep going. Thank you.
Okay, so we've talked a little bit about potential gaps in the unfairness and deception authority of the FTC Act. Now let's move on to potential gaps in the remedies that we seek. And so I'd like to divide the discussion into the kind of injunctive/behavioral remedies that we typically seek in our orders, and then monetary remedies. And so why don't we start with the behavioral injunctive remedies, and if I could ask Christine to comment, do you think that the FTC is using its existing toolkit effectively in crafting remedies in its orders?
I don't think that it has been effective. I think especially, I know it's difficult for us to say because of the privacy assessments, because they're so heavily redacted. So Epic has used Freedom of Information Act to get the FTC's privacy assessments that are under consent order, and that's really been, I think, the center of what's been held up in the consent decrees as this comprehensive privacy program that's really going to change internal business practices and really change the nature of how the company is conducting its data protection purpose. But we really haven't seen in the time since those big firms have been under consent order that those practices have really changed. So I think that is an indictment to us that this type of process isn't really having the effect that it was intended to.
Okay. Does anybody else have any reactions or response? Okay. Christine, can I just ask you a follow-up question? Is that, and the follow-up question is, do you have specific suggestions for other remedies that the FTC should be pursuing, or things that the FTC should be looking for in these privacy assessments?
Yeah, so one thing I think would be bringing those assessors or auditors under sort of control of the FTC rather than control of the one being audited. I think just one example, like Facebook's first assessment, the assessor, PwC, flagged an issue that the company wasn't assessing service providers' compliance with the data use policies that made it more difficult to detect issues with third-party developers. And instead of like remedying that problem, the next biennial assessment, Facebook was able to like change the standard so that it wasn't being assessed the same way it was the first go around. And I think that is an example of how the way these assessments are being carried out, the FTC should have greater oversight rather than the one being audited. I think it really compromises the independent nature that those investigations are supposed to have. And then as far as other types of remedies, I think that the FTC should be looking at antitrust remedies. I think even though the bureaus are separate, more collaboration between them and thinking about how antitrust and privacy issues are related would be a really, really big benefit to consumers. We think that unwinding some of the mergers that have allowed big firms to snap up their competitors and get those, like that data, that user data that's been so valuable and allowed firms to grow a lot more dominant and be able to just acquire their competitors before they're a competitive threat. I think privacy should be considered when that merger review is going on.
Can I just add one thing to that, which is sometimes it's even simpler. So when we brought our case against Intel, it started out as a competition investigation. And as we continued our investigation, it became a very strong consumer protection investigation, a UW investigation for gaming benchmarking systems to make Intel's chips look stronger than they otherwise would have been. At least that's what we allege in the case. And I do think that there is a fair amount of investigations and that would benefit from having both parts of the FTC House sort of working together. I noticed in the new technology task force, there appears to be some role for the Bureau of Consumer Protection. I just came out of an enforcement meeting. I apologize for being late. With Bruce Hoffman, I saw Daniel Kaufman walking in. So I thought that was a good sign. And I do think that sometimes if you pair your sort of antitrust competition thinking with the consumer protection thing, and Peter's written about this too, that you might come up with a better remedy and a sort of an innovative case?
Okay, so I think two threads have come out of this discussion. One is kind of what are the appropriate remedies, and the other is intersections between privacy and competition. So one of the things that we have heard from some panelists, from some public discourse, is that there's somehow, there's some ways in which privacy and competition may be at odds. So for example, if you are requiring opt-in choices for information, then maybe you are entrenching incumbents and not allowing smaller new entrants to come into the marketplace. I'm wondering if people have responses or thoughts on that, particularly since we're talking about intersections between competition and privacy.
So I guess I would say yes. There's sometimes some tension between a competition and a consumer protection approach to a matter. That doesn't mean that you shouldn't. And certainly, for example, the early returns on GDPR, are that it may raise barriers to entry. It may be innovation stifling. I don't know that we know that for sure yet, but that's certainly what we are beginning to hear. On the other hand, if some entity is engaging in a violation, you ought to go after it. And if you can tweak a remedy, going back to remedies, if you can tweak that remedy to make sure, sometimes it's with licensing, sometimes it's with those open sources, sometimes it's neither of those things, to make sure that there's less tension from the consumer protection side or vice versa, I think it's probably good. And I think you guys have think creatively in that context, or have, and will.
Peter?
So I have a historical example of a tension between privacy standards and antitrust. When I got to spend a year with Stu Ingus and a bunch of other people on Do Not Track, we were trying to come up with a privacy standard. And at one point, we were quite close to having an agreement, I thought. And at that point, there were going to be privacy rules that the browsers had agreed to. And as part of that, the FTC wondered, were there antitrust concerns having the browsers talking to each other in this way and coming up with standards? And so the week before one of the plenary sessions for Do Not Track, I basically did a 2-hour moot court with the FTC on why we thought it was not an antitrust violation to have this Do Not Track privacy rule. But apparently I wasn't persuasive, and so the next week when we went to our meeting for Do Not Track, we were told that if we went out with the proposal, that somebody from the FTC would stand up and say the FTC had serious antitrust concerns about the proposed agreement. This is highly relevant to, Stu wasn't in the room for that part. He has no blame for all that.
I was wondering why you pulled out of that deal at the last minute, but now it's clear.
It was the spring of 2013. We had what I thought was
John doesn't seem to know about it.
It was after John had left.
Oh, after John.
There's a lot of talk about, can there be self-regulatory standards? Can there be industry efforts to come up informed by consumers with good privacy practices? But at least in this instance, there was a decisive antitrust objection from the FTC to the deal.
Well, I just want to, defending my agency, and of course I was gone by then, I would say that if there was a will to reach a Do Not Track accommodation, there should have been a way to avoid, well beyond Norr Pennington, but there should have been a way to avoid serious antitrust concerns. That's actually an interesting newsflash.
No, I think for students, it is a newsflash for me too. It's water under the bridge. I'm teasing.
It's long enough now that I'll talk about it publicly. But it was very annoying at the time to have the deal fall apart.
Indeed, it was. I'll say. But I think Peter's right. Actually, forgetting about how the history was written. Maybe we should have a book written someday about it. But I do think Peter's right, and I think that point actually is more acute now than ever before. Whether it's true in motivations or just the reality of very successful businesses, if you allow 1, 2, or 3 companies to set rules, whether they reach conclusions that are against public policy or not, there will always be that perception from competitors. And there's always that possibility and potential. And so when you're looking for solutions for some of the privacy challenges, which could very easily be put with 1, 2, or 3 companies, it raises, I think, significant competitive issues.
Mark, did you want to?
Yeah, I just wanted to just push back on the actual question, right? Because the question was, does privacy cause a competition problem? No, privacy does not cause a competition problem. Responsible use of data does not cause a competition problem. What causes a competition problem is our current, today we have a sectoral approach, and so different sectors of the economy are regulated differently, which means that any change in the framework, by definition, necessarily is or likely to benefit some sectors over others, and we saw it play out today. If you're a company already subject to opt-in, then you are very eager to see everyone else get opt-in. If you're not, you might want a different approach. We're going to have to grapple with that as we create that framework. But it's not privacy itself. It is the current rules.
Yeah, and if I can just follow up, look, I agree there can be some tension between rules that are easier for the largest players to follow and sometimes dampen new entry. I think there are ways to avoid that, by the way, and I think we've tried to avoid that, or the FTC has tried to avoid that in many of its cases and in its thinking. But I certainly hope that if Congress, and I certainly hope Congress will move forward with some privacy legislation that will empower consumers, and if at some point there's a group from the business community that begins to say, this is going to entrench large businesses, I would look under the hood to see who those businesses are, who in the business community is actually objecting, because very often it is, and I hope that won't happen. I'm not so sure it'll happen, because I think there's a clear, I think there is a clear problem that we want to solve for, which is consumers need more control over their data. Some companies do it really well, some companies don't, and I just don't inherently see a federal approach that might have opt-in for sensitive categories of information, opt-out for other categories of information, inferred consent. I mean, it's just sort of along the, more rights of deletion and access, and maybe correction depending on the context. Again, I apologize for going to the end, from the middle, but of our panel. But we have to solve for a bigger problem, and I don't think that. And sometimes those types of objections, and it sounds like you believe that it was the case in Do Not Track, can be pretextual.
Okay, so let's just jump back to remedies for a quick second, because I do want to set up the last part where we're going to talk about what tools do we need to fill in gaps. But just sticking with the gaps and remedies for right now. Just to provide some context to the audience and to the panel, so I think I jumped into the remedies question without laying the foundation for what remedies do we seek in our orders. And I think they're typically things like data deletion, prohibitions on misrepresentations, in certain cases to have a privacy or data security assessment and get outside, or to have a comprehensive privacy program and get outside assessments of that program. And so we heard from Christine the kind of limitations of that approach. We also heard from Christine ideas for additional remedies we should be including in our orders. Does anybody have any other comments on that piece? Are there additional remedies we should be including in our orders? Christine had the idea, or she mentioned some other remedies, including kind of unwinding mergers and other competition-based remedies. Anything else that we should be considering? So I think the premise for this question is that, we can talk about legislation, and there's been a number of groups that have recommended legislation. But until legislation passes, we have the authority we have. And so what I'm looking for is kind of ideas, tips for filling in gaps in a way that's consistent with our legal regime. Comments?
Well, I guess one thing is, you might think about, and I understand that resources is a difficult issue, but you might think about some allocations of resources to making sure that the behavioral remedies associated with an order are adhered to.
Good. Okay, why don't we move on to the related topic of monetary remedies? So I guess two questions under monetary remedies. One is, should the FTC pursue monetary relief under the existing regime in our cases? And if so, how could we measure? So again, just to provide context, we can currently seek equitable monetary remedies, disgorgement, redress. And so should we be seeking more of that relief in privacy cases? And if so, how would we measure that? Can I ask John to kick us off on that?
So do I think you should be seeking monetary remedies? as a form of equitable relief in privacy cases? I think you should. I think there are circumstances where there's a harm to consumers or unjust profits to malefactors that make a lot of sense. I do think when you are looking at, and then of course, if you have a privacy violation that is statutory, could come out of COPPA, or that is so clear, and that's the case of the people sitting in the back office watching cameras, on the computers that are watching people in their bedrooms, then of course you should. My own sense, though, is that it is hard to reach. It's hard to reach the kinds of harms that relate to people's true privacy and dignity with a monetary remedy. That doesn't mean you shouldn't try, and I kind of think of Vizio as being an attempt to sort of, to try to do that. But I guess my view is that probably a better way to do that would be to sort of think about giving the FTC some type of upfront, and I know not everybody agrees with this, some type of upfront finding authority.
Anybody else? I think that there are two kind of paradigmatic examples of the types of privacy cases. One is kind of somebody has a network data breach, and how do we seek monetary remedies in those cases? And I think the other is kind of a company has sold a product, like an IoT product or a smart TV in the case of Vizio.
Right.
And I think we've heard that there are challenges. People have mentioned challenges in both scenarios. Anybody have any comments on that?
I'm not sure it's exactly on point, but to the extent that the consent decrees have litigation risk associated with them, which we were discussing earlier, having a new statute from Congress that made clear that monetary fines could be pursued for injuries that Congress helps define would really address that litigation risk. And I think the FTC would then have a much stronger hand when they see something wrong to say, it's not like you're going to pay the second time, it's that we really have a problem right now. And so I think a wide range of people from different parties have called for civil monetary penalties at this point, and it would address some of the weaknesses we've seen in the litigation.
Well, here's something else that you could do, now that I should have thought of this before, is actually the Justice Department, and I'm not necessarily an advocate of this, but it's the kind of thing you should be thinking about. The Justice Department's Antitrust Division has gone to a preponderance standard for order violations. They've inserted that in orders. Now, it was not by companies that are on the receiving end of that. It was not particularly appreciated, but I certainly remember thinking about order violation cases when I was at the FTC, and it's a clear and convincing standard, isn't it? And we had to proceed with some caution, recognizing that there was a very high burden on the agency.
Okay, Stu, did you have a comment? No. Okay. Okay. Last question, and then we'll move on to the last part. So the FTC has other tools besides enforcement. It has kind of the power to convene these types of workshops. It issues reports. It does 6B studies. To what extent should the FTC be doing more, or less, or something differently in these kind of non-enforcement realms? Jane?
I think the workshops are helpful, and I think allowing consumers generally more access to the FTC. So I might consider going out of Washington and visiting and holding some workshops across the state so you can hear from different consumers more generally than the privacy complex that we usually see at these meetings. You might actually get some consumers in the room to talk about their concerns.
Just words of praise for what the FTC's done in this area for the last bunch of years. We're here today, and you have people in busy lives flying in from lots of places to be here. You have national webcasts, and there's a history of ideas being floated at these workshops that then get put into the stream of what people should consider. So it's clearly been an area of leadership, I think, for the FTC.
Okay. Christine?
I'll say, I mean, I would never argue against more workshops and research and reports, but I think, you know, that the FTC is the only one that really has enforcement authority in the federal, you know, sphere, and civil society and academia can pick up the slack if the FTC isn't able to hold as many workshops or do that sort of work, and I think the focus should really be on enforcement.
Okay, Jim.
Okay, so we're going to wrap up the panel by discussing the possibility of additional FTC tools and resources. Why don't we start off by talking about potential new substantive privacy legislation, since that's come up a number of times during the panel. If Congress does enact comprehensive privacy legislation, what should it look like? Should it be based on the Fair Information Practice Principles? And how might a comprehensive law based on the FIPS account for differences in uses of data and or sensitivity of data? And Stu, can you start off that portion of the discussion?
Thanks. Working with a lot of companies and leading trade associations that are in the consumer economy, we launched just on Monday an effort called Privacy for America. The details you can see on the webpage. I don't want to make it a sales pitch about it, but you can look at it. But it was all intended to start and push forward in improving the consumer experience, based on a premise that the consumer experience is broken. The transparency it's important, it's sufficient, but it's not enough. It doesn't give enough to consumers, and it's too much, whether it's opt-in or opt-out. The consumer experience, they're tired of all the clicks, particularly in what's happened in Europe, the I accept. And the approach that we have been pushing and working through on details we call a new paradigm, because it's different from the old paradigm of just transparency and choice. And the new paradigm would have much more in the way of specific prohibitions. Many of the things we talked about on discrimination and other things. On that point, tied to an earlier question, there are all those laws that other agencies enforce on those areas, but none of them have the focus that I think in this day and age should be specifically on data and the enforcement tools behind that. So you could put that within the FTC, and then you'd have appropriate practices, define stuff that benefits consumers, retooling some of, particularly the stuff of the non-sensitive advertisements that benefit and give consumers things they're interested in at a relevant time. So in the announcement, we called for a nationwide standard, prohibitions on certain practices, creation of a new Bureau of Data Protection within the FTC that would resemble in many ways, I think the closest analogy is the FDA. There was a time where drugs and different things were being put out in the world without the right regulation, and many people in the pharmaceutical industry would tell you that saved the industry. And the level of benefit that can come from data justifies just that, and it requires just a much broader new paradigm, really a lot of what Mark was saying at the beginning. Step back. I won't go through more details now, but I'll just make one point for many of us, certainly on this panel that have been in this debate for many years. I think the opportunity is actually here now for a law. I think there is consensus. Manisha, you highlighted some of it earlier, but there is consensus. The details matter. We've got to get them right, and we got to do a hard work on that, getting beyond the rhetoric. But I think there is consensus that is the time for a national standard that could really redefine both the limits and benefits and framework around data in the information age.
Does anybody want to respond to that general description of what privacy legislation might look like?
Okay.
Peter?
Professors talk too much.
It's lawyers, not just professors.
Well, and it's worse if you're a law professor, right? Okay. So, so the issue of preemption gets talked about a great deal, and it can be relevant in this setting. So I wrote a couple of articles on the history and issues in preemption for privacy legislation earlier this year for IAPP.
And Pam Dixon and I are working on a possible proposal just as a thought experiment for preemption maybe being a carrot, a reason to come into industry defined with advocates participating, but then with FTC approval, if you have basically a clearly strong set of standards, there's a reason to maybe say yes to those standards because then you'd get the preemptive effect. If having straight out preemption is going to be very controversial on the Democratic side, having preemption if there's demonstrated strict standards and somebody watching the standards might be something where both sides could end up thinking that's better than the alternatives. So we're trying to see whether something in that direction might be a way to, and it wouldn't just be industry-defined standards. There would have to be some ability for notice and comment and for participation from different points of view. But that may be a way to change, to adapt over time what the standards are and to address the new things that come up in the data economy.
Jane, did you want to weigh in?
Sure, I'd be happy to, and thank you so much for inviting me today. I'd also like to stress that we would be looking for something that's globally interoperable. As a global business, you want to build your privacy compliance framework around strong global principles. And so that's something we'd be looking at, and I'd like to outline a few of those principles that we would be looking for in a federal privacy law. We'd like to see that it's generally applicable across different technologies and industries and business models, so it sets a baseline of protections. We'd like it to apply to all persons acting in their personal capacity, with a definition of personal information that is consistent with the other laws, such as GDPR. And we do think there is a need for a controller-processor distinction. There should be different obligations placed on them depending on their relation to the data. And there should be a distinction between personal data and sensitive personal data, a higher level of protection around sensitive personal data. We do think there definitely needs to be transparency and notice. And we think that there is room for innovation in this area. And one of the things that we've recently innovated on is we've introduced a new privacy icon. And whenever you start a new product or service that collects your personal data, you'll see the hand shaking. And right under that icon is all the key privacy information that you need to know before you actually start that new product or service. And importantly, the icon won't show if the product doesn't collect personal information. So that's one of the ways that we're trying to be innovative in transparency and choice. Next, I would say data minimization, crucially important. There's so much data out there. And we should really challenge businesses not to collect data unless they need it. And if they need it, do they really need to collect it associated with a personal identifier? There's a lot you can do with random identifiers when you're collecting data up to your servers, like, for example, Siri and Apple Maps both use random identifiers that are generated on your device, and then we're able to sync that data across your devices using an encrypted cloud, so Apple doesn't see your data, but your devices are smart. We'd also say that the privacy law should require that the processing has a legitimate legal basis. I actually think the GDPR was sort of innovative in that area. It's not just a notice and choice law. Again, individual rights of access, correction, deletion, and the right to objection to processing, and then a robust security program. I also think that it's time that we handle data breach notification consistently across, and it's an opportunity to put some consistency there. And then I'll just finish up with the data brokers provision, and then I'm finished.
Can I throw out one question, and then we'll go to you, John? One of the things I want to drill down on, Jane, that's one of the few mentions of data minimization during the hearing. Can data minimization be legislated in a meaningful way? And how, beyond telling companies to not collect what they don't need? And I would add to that, who defines need, and how would policymakers or an enforcement agency look at need?
I
think we've been in a black and white place for the last decade where everybody's been arguing we need all this personal information to create really cool services, and that personal information needs to be identifiable. But I think there are a lot of other ways, pseudonymization, what I mentioned with the randomly rotating identifiers for maps. So the data is not identified, it's not connected to an identified person. So you can do data sampling. There's a tremendous amount you can do without collecting strongly personally identifiable data to comply with data minimization. So I think a law should require businesses to collect the minimum amount of data that they need to achieve the purpose of collection. I think it's very reasonable.
John?
Yeah, I actually think Jane has, she's been thinking about this for a long time, and she has some very, very good ideas. It immediately occurred to me that you could take some of those best practices and turn them into a safe harbor. I would rather have the FTC thinking about this with a delegation of authority from Congress, perhaps than Congress trying to write this into a law, other than an admonition to the FTC that you should figure out a way to implement this. But we'll see. I guess I would say that you can't, just listening to what the other panelists have said, and I agree with a lot of what they said, that, that Congress, if it moves forward with legislation, can learn something from GDPR and even from California, right? It's lawmakers who actually, or elected officials who actually passed legislation protecting privacy. They're flawed in some ways, but it is in many ways provoking that debate in Congress now, which is a very, very good thing. You can learn a lot. I see Julie Brill sitting here, and you can learn a lot from the Washington State bill as it moves forward or doesn't move forward. But as it proceeds, but I also think, this commission can look at its own work product, going back to the 2012 report that we issued and then subsequent reports that build on that, because it really gives a framework that I think actually articulates the notion of empowering consumers to control their data, right? It is opt-in for sensitive categories of information, opt-out for other categories, with the exception of inferred consent. It's platform neutrality, which is critical. It's rights of access and deletion, and I think minimization is talked about in that report as well. It's enforcement authority for the FTC that would include fines, some rulemaking. Enforcement authority for the FTC is something that will come in federal legislation. It's not exactly in the FTC report, as might some degree of rulemaking authority. Increase resources. This agency is smaller now in terms of FTEs than it was in 1980, when the population of the United States was 125 million people smaller, and the ability to to investigate a case was, monumentally simpler. I think we do need one strong federal standard. I think that is appropriate. Data doesn't travel in, data doesn't remain in a single state. And I think most people, not everyone, but I think most people from in the consumer movement sort of recognize that if you could have a strong federal privacy regulation or law that protected consumers in every state, that would be preferable to a handful of states. But I sort of think of sort of preemption as something that and by the way, in California, it's worth noting that when California passed the CCPA, it preempted all municipal privacy regulations, right? And GDPR the way GDPR is implemented, you don't have a lot of competing nation regulations, you have implementation by them. So it wouldn't be unlike the FTC and state AGs, engaged in joint enforcement efforts, which they do under COPPA. But it sort of strikes me that you can't get to the preemption question without having a strong bill behind it, right? Or without building a strong piece of legislation that would really protect consumers.
Great, thank you. Mark, did you want to add something?
Just in terms of legislation looking forward, any framework that we look at has to obviously take into account the future, not where we are today. And I think the future is data that is inferred about people. It is not data that is provided. It is not, I'm not worried about the data I gave to a company through a website. That's 10 years ago. We need to focus on observed data and inferred data and make sure that any framework captures that. I am a huge advocate that surprises people of a risk-based framework. I think that is actually what we're going to have to do given the range of business models and be able to evaluate risks from any model. And finally, the question about minimization, when you talk about FIPS, the way I envision the framework is that companies need to have some options here, and based on risk, I look at the FIPS as tools or dials, and so you can ramp them up or down to provide different levels of protection given a different model. The downside with that framework is that it requires people to think.
Okay, so we have a very few minutes left. I'm going to give each panelist an opportunity for a less than 1 minute wrap up, but we're also going to try something fun here. In addition to your 1 minute wrap up, you have a very illustrious set of panelists on the next panel, and we're almost all the way through the event. So if there's one question that has not been answered or one issue that has not been discussed that you would like us to tee up on the next panel, because Jim and I are going to be moderating it, let us know during your final comments. So why don't we start on the end with John and move our way?
No, look, I think these.
Hammer Vladeck.
What?
Hammer Vladeck.
Hammer David Vladeck, yes. I think that's an excellent idea. Bring it on.
This is your chance.
Yeah, we'll have a few different options for that. We can turn up and down the dials, as Mark just said. For me, no, I think this is great. I think you guys should, I would say one more thing. I think you should get very engaged. I think you're sort of starting to do this, but I think this agency should get very engaged in thinking through privacy issues with Congress. If Congress moves forward, chance this year, big chance, if not this year, then in a couple of years. You want to be present at the creation and you want to influence that process. The other thing I just want to mention is that while I do represent a few tech companies and broadband companies on privacy, a lot of broadband companies on privacy issues, I'm speaking as a former official and not in any client-related capacity.
Peter.
I'm also speaking as an individual. So is Justin Brookman here? I think he's on next.
He's on the next panel, so.
Yeah, okay, well, he might not hear this, but I want to know if Justin's work at Consumer Reports, if there's a way that can or should be incorporated into law by reference. If so, if we have really good consumer ratings on privacy, is there some way to give it even more teeth? I don't know if that's good or not, but that's my question to Justin. I'm trying to say some things that I think if Congress moves forward, and there's reasons why it should, having good findings, having good hearings, building a record will be important to how that law survives in the courts later on. There are recitals in GDPR, but for instance, on preemption, there's hundreds of different state laws, and there needs to be work done on issues like that to build a record so people know what's covered and what isn't. And unless that homework's done, there'll be tremendous problems after passage of legislation.
Okay, 30 seconds, Stu.
Well, congratulations on another successful couple of days. As I indicated, I think that it is the time now for a bold and strong new paradigm, a different approach, building on the successes of the various issues, the various laws. There's some pros, some cons to all of that, but I think this is the time, and I think we all need to work together on the details.
For that.
Jane.
And as the representative of industry on the panel, I think I will just reiterate that we are very, very much in favor of a federal omnibus privacy law. We think it's good for business and good for our consumers, most importantly.
Mark.
First, I want to say that given your current resources and authorities, I think the FTC has done an extraordinary job in this space, given what you have as authorities, and your statutory framework is incredibly impressive. And then I am going to have a question for the next panel. So here's my question. If we have a federal privacy law, there's been a lot of discussion about preemption for states. I think equally difficult is, if you have a federal privacy law, what happens to GLBA, HIPAA, FCRA, Cable Act, VPPA, FERPA, and the other 18 federal privacy laws that all have different standards that contradict each other or are inconsistent? And when you remove them, you are going to have competitive effects. So when we do a federal privacy law, what do we do with the other federal privacy laws?
Christine?
Well, I want my last point to be arguing against preemption. I think states are a lot more agile than Congress and are able to respond to emerging privacy threats a lot more quickly. No one really thought that all 50 states and the territories would be able to enact separate data breach legislation before Congress could pass a bill. So I think it's really important to preserve the state roles, and the states have been a lot more effective than the federal authorities historically in protecting consumer privacy.
Okay, with that, I want to thank all of our panelists. Please join me in giving them a round of applause. We have a break till 3:45, so welcome. So please return at 3:45.
Okay, we are in the home stretch. We're back for part 2 of our panel on the adequacy of the FTC's current toolkit for dealing with privacy issues. Our esteemed final panel includes Julie Brill, the Corporate Vice President and Deputy General Counsel for Global Privacy and Regulatory Affairs at Microsoft and a former FTC Commissioner. Justin Brookman, the Director of Consumer Privacy and Technology Policy for Consumer Reports and a former Policy Director of the FTC's Office of Technology Research and Investigation. David Hoffman, Associate General Counsel and Global Privacy Officer at Intel. Lydia Parnas, a partner at Wilson Sonsini, Goodrich, and Rosati, and a former Director of the FTC's Bureau of Consumer Protection. Baron Soka is the President of Tech Freedom. David Vladeck is the A.B. Chettle Jr. Professor of Law at Georgetown University Law Center and also a former Director of the FTC's Bureau of Consumer Protection. I'm Jim Trilling from the FTC's Division of Privacy and Identity Protection, and my co-moderator is Manisha Mithal, also from DPIP at the FTC. So we are going to start off the same way we started off the last panel, which is to talk about metrics for measuring the success of the FTC's privacy work. Lydia, I want to start off with you. How can the FTC and how can the public and stakeholders in general measure FTC success when it comes to privacy issues?
So, Jim, thank you, and thanks to both you and Manisha for inviting me to participate in this panel. I just have to say, what fun to do this after listening to the fabulous panel that went right before us discussing these same issues. So, I think this will be really terrific. I agree with many of the sentiments that were expressed on the earlier panel about measuring the FTC's success, but I want to call out Mark and Stu in particular. I totally agree with Mark. I always have about everything. But on this point that it is very hard, maybe even impossible, to actually measure privacy, measure the effect of the FTC's efforts in the privacy area. But, I also think, as Stu said, and, I would imagine that almost all of us agree with this, the FTC has been extraordinarily successful in this area over the past, 20 years, 25 years. Just, it has been incredibly impressive that it has developed this, what is referred to as this common law of privacy. It has done so because the staff is incredibly creative, and also, I might add, because the people who wrote Section 5 really were brilliant. It is broad, and it gives the FTC exactly the kind of authority to deal with issues that were never envisioned. So, when our panel met, Manisha said this was going to be a really hard issue, and it is. So I've tried to kind of unpack it a little bit differently. When you talk about the effectiveness of a privacy program, the first thing I think you have to do is define what the goals of the program are, and to kind of set goals for any program. An agency like the FTC really needs to define goals that are recognized in the community by its important partners and stakeholders. And so valid with the commissioners and the staff, obviously, but also with businesses that have to implement these privacy programs, academics and others who study these issues, other government agencies who are engaged in adjacent enforcement efforts, and also honestly, the Commission's congressional oversight committees. I mean, they are important stakeholders as well. starting at a very high level, I think you would get agreement that the FTC's core mission in consumer protection and in privacy as well is advancing consumer welfare in the market. I mean, those are the basics. It's very general, but it really is core, and I think it is such a central principle that you always really need to kind of come back to that. I think the way it's played out in the privacy area is that, you know, it's really been about the FTC staying ahead of the curve. You know, the commission staff has looked at, you know, the market. They've identified new technologies as they've been coming, as they've been, you know, kind of coming to market. They've been internally noting what they think are potential problems and perhaps gaps and maybe misunderstandings at the business level of how the law applies to these new technologies. And they've been thinking very hard about how old law should apply to these new technologies. And then they've gone out, they've convened workshops and hearings like the one we're at today. They bring together stakeholders. They define what the standards and the guidelines should be. They articulate them, and then they set out expectations. They, you know, kind of translate all of this into understandable language so that consumers know what to expect. You know, that's a pretty complicated process, but really, when you start thinking about measurement, that process seems easy. I think it really is a challenge. We don't, you know, I know that each portion of this panel only has a few minutes. So what I'd like to do is just lay out a couple of things that I think are worth having the Commission consider. You know, I started out, I was thinking about an article that Deirdre Mulligan and Ken Bamberger wrote in 2010. It was called Privacy on the Books and on the Ground. And it reported on research that they had conducted. They interviewed, you know, kind of dozens of chief privacy officers who had been identified to them as leaders in their field. And among other things, they found that the emergence of the FTC as a privacy regulator in the mid-1990s really had a very significant impact on corporate America's kind of effort to go out and hire chief privacy officers and invest in privacy programs within their companies. And companies and these chief privacy officers called out enforcement. They said, oh yeah, we really pay attention to FTC enforcement efforts, and we want to, you know, kind of do our best to have programs in place so that we don't get we don't get called out. What Deirdre and Ken basically concluded is that then, I think, as Mark pointed out, there was, you know, in the 90s, there was the same debate we're having now about, you know, is privacy on the books adequate? And what Ken and Deirdre said is that while people were busy arguing about that, privacy on the ground was actually growing. And it was growing in very large part because of efforts that the Commission had entered into. So I just want to kind of make one quick suggestion about a way in which the FTC can actually attempt to measure success. When the Commission steps into an area, identifies a new area, and like mobile apps was a good example of this, they are really investigating what this market looks like. And then they intervene, and then they see change. And I think in mobile apps is a good example. They did see, you know, kind of no privacy disclosures, and then after intervention, very significant privacy disclosures. I mean, this is something that I think the agency should do much more frequently and build it into reporting as well.
Thanks for leading us off. David Hoffman, do you have thoughts on how the FTC and other stakeholders should be measuring the FTC's work with respect to privacy?
Yeah, absolutely. And I think Lydia's comments are fantastic. I would say that privacy on the ground has grown tremendously. A lot of that has been caused by the great work that the Commission has done implementing Section 5 of the FTC Act. I think, as Mark Roman said on the earlier panel, I think the FTC has done a tremendous job given the resources and the authorities that it has. I think, though, while privacy on the ground has grown, the risks have likely grown even more. And I think if we want to take a look at the risks, people in the United States are right now saying there's a privacy crisis. They want people to step in to provide better protections for them. That's why we had the voter referendum in California. It's why we now have the California Consumer Privacy Act. It's why we have similar laws being created in over 20 states that would potentially create a non-harmonized patchwork that, frankly, running a privacy operation for a large company, I have no idea how we would potentially implement. I think much of this is driven by the fact that we have a completely unregulated industry of data brokers that don't get their information directly from individuals. I think if you're looking for an opportunity to measure and take a look at how advances in data analytics and data availability are transforming that data broker industry and the risks that they're creating, and measure whether you're able to reduce that.
Justin?
Yeah, I would just say that I think one way to, or at the very least, I think what you would need to do is there needs to be better alignment between consumer expectations and understanding, or maybe even preferences, and then actually privacy practices, right? Because I think today there is a huge disconnect between what actually happens. People have a kind of vague sense of their privacy is being violated. They don't really know how. They don't really feel any agency. And so I think there's like a couple ways you could do that. One, you could kind of try to constrain data collection and sharing practices to be more consistent with context, to kind of get to where people expect it to be today. Or you kind of go the other way, get full transparency, make sure people understand what's going on. There's buy-in for this kind of dystopian surveillance of all against all. Facebook's listening to our conversations. But the idea that pointing to the mobile app ecosystem as a good example of privacy on the ground and people understand what's going on and it's limited data collection and sharing, I think is a somewhat startling idea. So we're doing actually some research right now into consumer understanding of privacy. It's kind of like an arc you see over 20 years. Kind of starting out, people are very cautious, nervous about being online, to people get kind of comfortable, social media becomes big, and then it's kind of coming back around. People starting to feel less comfortable, feel that their privacy, again, is being invaded in these ways they don't understand, and they resist and rebel against, but don't really understand what they can do or how to make the situation better. And so I think narrowing that gap, however you want to do it, is necessary, maybe not sufficient.
One of the related questions that has come up repeatedly during the hearing is how should the FTC or how can other stakeholders, for example, how is Consumer Reports undertaking the task of learning what it is that consumers expect?
Yeah, so Peter's one of Peter's questions was what the law needs to do to allow us to do our job. So Consumer Reports, in addition to advocating for better privacy laws and regulations, also tries to evaluate products based on privacy and security. We've done a number of those ratings. Some of the challenges we're running into. So one, transparency. I'm sure we're going to talk about this with deception today, but companies have privacy policies. They have privacy disclosures. They're not really required to say much in them. So if I'm looking at two apps' privacy policies, I don't know. It's actually really quite challenging to say which are better. I know there's some debate around what the role of privacy policies should be. Should they be super simple and easy to read, right? The Kennedy-Klobuchar bill does that. Or should they be really detailed, not for consumers, but for folks like the FTC or for Consumer Reports or for academics? And I lean very much toward the latter, that you should be required to put more detail about what you're doing. Two other things that I jotted down in response to Peter's question. One, the deception statement today talks about deceiving consumers. I think that concept should be broadened to deceiving testers and maybe regulators as well. So again, like the Volkswagen case, example of like running, secretly trying to figure out what's going on and changing how you perform in different environments. We don't know whether what we're testing in the lab is performing as it would for a normal consumer, so maybe clarifying that as well. And then just making things more testable. It's really actually hard to test a lot of stuff. And so, one, the law actually kind of disencourages it or makes it illegal in many ways, getting rid of those prohibitions, but also maybe making some obligations of testability, opening up APIs so third parties can hold folks accountable. And I know Microsoft talked about this idea a fair amount, would be a great idea.
Okay, so why don't we move on? So I think the next topic that we want to cover is what are the gaps in the FTC's existing authority? Because I think what we want to eventually go towards in this panel is what additional tools or resources does the FTC need? And we can't have that discussion without having a discussion of what the current gaps are. So again, we're going to divide this discussion into two parts: gaps in our authority over unfairness and deception, and gaps in our remedies. So I'm going to tackle the gaps in unfairness and deception. Now, I've heard really 2 points of view about unfairness and deception. One is that, well, you can go after companies that deceive consumers and you can go after harmful practices. What other substantive rules do you need? And are there any other privacy practices that should be violations that are not violations under Section 5? So that is one point of view, that the status quo is the right approach to protecting consumer privacy. The other point of view is that unfairness and deception have severe limitations. They don't get at all privacy violations, and therefore we need a substantive privacy law. And I just wanted to ask the panel where you fall on that kind of divide, and if you have any thoughts about the limitations of unfairness and deception in this context, and maybe I could ask Barron to kick off that discussion.
Sure. Well, let me start by just noting that the only 2 people of the 8 privacy lawyers on this panel that have not worked at the FTC are David and myself. There's a lot of experience on this panel, and a lot of people who've been in the trenches. And I would commend all of them and all the people who've worked at the FTC over the years on privacy, but also on consumer protection. The roots of what we're talking about here today go back for decades. And I think it's really important to take a moment to acknowledge and appreciate everyone who's done that work. Lydia mentioned that the people who wrote Section 5, specifically, she's referring to the Wheeler-Lee Amendment of 1938, they were very forward-looking. But if you really want to go back and look at where the FTC gets its ideas today and start to answer your question, Manisha, I think you have to go back and look at the fundamental policy statements that have guided the FTC to where we are today. So I'm just curious, as I get started here, just want to get a sense of the room. Tell me where you think this quote came from. Quote, "There are many more or less sentimental considerations that the ordinary man regards as important." So do you think that was something that David said, or something you hear today from a Democratic FTC commissioner? Any guesses? Well, I'll tell you, you might be surprised, this came from the Republican FTC in 1983 in the deception policy statement. All right, so if you go back and you read these fundamental documents, and I try to do this whenever I re-engage on FTC issues in a deep way, I go back and I reread both of them. There's a lot there, a lot of distilled knowledge about how consumer protection law evolved in America. And one of the things you realize when you read those documents is that some of the things you think of as partisan today, they're not. They're really about how to think about harms and how to measure consumer expectations and vindicate them. And it's often said that the FTC's job is to protect consumers against harm. Well, that is the primary thrust of the FTC Act, and that's what unfairness requires, and that's what you see in the 1980 unfairness policy statement. And you'll see language in there that expresses some skepticism about non-financial, non-tangible harms, and there are real questions about how to measure those things. But if you go back and look at the deception policy statement, which was issued not by the Carter FTC, as the unfairness policy statement was, but by the Reagan FTC, you see the sentiment that I just expressed to you. And the reason that the Commission gave that weight, quoting the restatement on torts in that particular quote, gave that weight to subjective considerations was that they understood that if you looked at those through the lens of what affected consumer behavior, of what was material, of what caused consumers to make decisions based on something that was told to them or something that should have been told to them, an omission, that you could get at a lot of the problems of consumer protection law that were otherwise insoluble, that required too much direct evidence, that a regulator would never be able to show to be an effective cop on the beat for consumers. So to go back to your question, Manisha, I put myself in the middle. I think that we don't give enough credit to the people who wrote those two policy statements and to what actually could be done under the frameworks of deception and unfairness today. The discussion on the last panel about materiality really illustrates the point. We can talk more about this later, but I think people have not really thought about materiality in a rigorous way, because the deception policy statement allows the Commission to presume materiality in cases of explicit statements. And because they've done that, the only cases where the Commission's had to really demonstrate materiality have been an omission. So number one, I think if we thought more about that, we'd actually start we'd have an analytical lens for thinking through these problems. But two, even if you think that the current approach to unfairness or deception are too limited, it doesn't mean you should throw them out and start with something completely new. From my view, the history of consumer protection law in the United States is that Congress has come around again and again and enacted specific statutes that build upon those concepts, that effectively say that certain practices, like for children's information or credit reporting, are presumptively harmful or are presumed to be material to users. And if you take that approach, you can see an approach that evolves out of those concepts. Now, it doesn't break with them, but it grounds whatever it does in those terms. And in particular, it means that if you're going to craft a flexible standard, like respect for context, say, that you do that in thinking about materiality. And if you do that, I think you wind up in the middle.
Okay, thank you. So let me follow up with two questions to anybody on the panel. So the first question is unfairness and deception enough, or are there gaps that substantive privacy legislation needs to fill? And the second question, I want to pull on one of the threads that Barron mentioned about presumptions of materiality. We had a case a couple of years ago where we had different statements from commissioners involving a deceptive statement in a privacy policy. And some commissioners said that we should not presume express statements in privacy policies are material because consumers don't read those privacy policies. And so I think they were highlighting a potential limitation of deception. So I wondered if anybody had a comment on that. So again, the two questions, the more general question and the more specific question about deception. Does anybody want to take on either of them? David? David and then Justin.
Yeah, let me start with the unfairness policy. First of all, Barron is plainly right that the FTC Act has been augmented over the years. I think there are now more than 70 statutes in addition to the FTC Act that the FTC is charged with enforcing. So it's not just an accretion, it's been sort of a landslide of the statutes. But you know, these statements take on a life of their own. There's a common law of unfairness and there's a common law of deception. And I think that, you know, it's interesting, the first of these hearings, Tim Muris talked about the unfairness statement and cited the Pfizer case, which was a case in which there was non-economic injury. But it was an unfairness case. It was not a deception case. My own view is that's the right reading of the unfairness statement, but that's not the way the Commission has been viewing it for the last decade. And so it may be that we need to retool or tinker to get back to what, you know, an originalist would call the original intent. Because if Tim and I agree about how to read the unfairness statement, it's got to be right. So that's the first point. With respect to materiality, I think the question that Barron raises is a fair one, but I think the reason why the statement is written the way it is simply out of, again, a history in which materiality was easy to prove. There's always a defense that a statement is non-material, but the Nomi case, which is you're talking about, was just a lie. It wasn't deception in the sense of a misstatement. It was just a lie. People were told that if they did certain things, if they wanted to opt out there, they could do it, but if not, they could opt out when they got to the store. That was just not true. It may not have been their intent, but it was a false statement. And under FTC law, false statements ought to be actionable.
And I'll promise that we'll argue about this later over drinks.
Okay, Justin?
Yeah. So, I mean, I think you can cram a lot into unfairness, right? I mean, I think the Vizio case that's been talked about is a good example of that. That's a case where effectively saying the collection of, even the first-party collection of sensitive data without clear permission is illegal, right? And if that really is the case, then, like, again, the mobile app ecosystem where geolocation is traded all the time, maybe that's all illegal today, right? If TV viewing is sensitive, then why isn't web browsing, right? So maybe you could get to all that. I think it'd probably be better to have a dedicated law clarifying what the obligations are. I mean, we can try to do it in unfairness. Let's do it more consciously and try to decide what actually is there. Again, things like access, correction, deletion. You can argue, I guess, that it's unfair to do that. Again, I think a dedicated law would be better. Getting quickly to the point around materiality, and it does tie into what I said around testing. Again, privacy policies aren't for real human beings. They're for folks like me. We rate products based on privacy policies. We distill that information to consumers to digest that in reasonable ways. If companies are allowed to lie at will in privacy policies, we can't convey that information to them. And therefore, it translates to misinformation in the marketplace. I know this is the hobby horse of barons. I have never understood it. But having some sort of affirmative obligation to say to the world what you're doing so folks can hold people externally accountable is a fundamental idea.
Well, may I try to explain? This is a false binary. I'm not arguing that privacy policy statements can't be the grounds for deception actions. The question that Manisha asked us is, should we presume that every statement in a privacy policy is material? And my answer is no, that the FTC should have to prove that. And the reason is, you go back and read the deception policy statement, and you read Central Hudson, the Supreme Court case that set forth the commercial speech doctrine, which was quoted in this deception policy statement. The court specifically says, in the absence of factors that change the incentive to make the statement, yes, we presume that a statement made in an advertisement is material. But what they and the deception policy statement make clear is that we're only presuming that because that makes sense in the context of something that a producer says to convince a buyer to buy the product. Where that relationship does not hold, you can't make that presumption. And if you do, you dispense with the entire analysis by which the Commission got to that point. This is just clear on the face of the deception policy statement. Now, again, I think that you should be able to pretty easily show that these things are generally material, but not always. And the NOMI case is really important. And I wrote a long paper about this with Jeff Manny. The key detail in NOMI, yeah, I agree, it was a problem, right? And it could be actionable. But the thing is that the statement they made was a statement that made on the website that you could opt out in the store. So that anyone who went to the website who saw that thing had the ability to opt out right there on the website. The Commission's argument was, well, what about the consumers who went to the website and didn't want to opt out there, but might have wanted to opt out in the store? When they got to the store, there was no opt out. Oh, come on, that can't be material. It's a false statement, apparently on the results of negligence by the part of NOMI to implement that system.
You can't negligently make a false statement.
My point is that you're conflating, David, the idea of the misleadingness of the statement with the ability to presume without evidence that it's material. And what this really gets at is that the Commission, because of this presumption, has not developed a concept of materiality, an empirical methodology that would be useful in other cases that we see today, like Facebook didn't tell anyone about the Cambridge Analytica thing. Was that material? Seems so to me, but I don't know what to point to in showing you what the methodology looks like. I would like to see more of those cases litigated.
So I'd love, as much as I'd love to continue this, I'm going to have a call on Julie next, but let me just throw another question into the mix as we're contemplating this issue, which is that it does seem that people have said that there may be some limitations in unfairness and deception. And so let's assume, we're going to talk about kind of potential legislation, but let's assume that it takes years for Congress to enact legislation, or Congress doesn't enact legislation right away. And so we have the unfairness statement and the deception policy statement. Should we modify those statements to take into account privacy issues? So, Julie, you wanted to chime in, and you can chime in on this question. Or
Sure. So first of all, thank you for inviting me, and congratulations on not only this set of 2 days, but also the entire set of hearings. I think they're incredibly interesting and really raising some great questions.
If we were to take this conversation and bring it to Brussels or bring it to Beijing or bring it to Sao Paulo or any other capital, it would be very, very foreign. This notion that we should be focused on unfairness and deception is a conversation that the rest of the world is not having about privacy. So if you wanted to really think about an appropriate metric for privacy, one argument would be, to what extent is the FTC affecting the actions in boardrooms? To what extent is the FTC the topic of conversation in C-suites? I'm a big, huge fan of the agency. This has nothing to do with you all. It's really about, I think, the laws and the relevance of the laws today. I'm also a big fan of Deirdre's book that Lydia talked about. It was written in 2015. This was before GDPR. It was like kind of as GDPR was kind of going through some of its final stages. I think if that same book were written now, there would be a very different reaction in the C-suites, even among CPOs and whatnot. It is true that in America we have a deep culture around compliance, and that is a very big difference here in the United States than it is in some other places of the world. But right now when people are thinking about compliance, they are not thinking about the FTC Act. They're just not. They're thinking about other laws around the world, and in particular about GDPR. So if we really want to have a metric that says the United States and its enforcement agencies are going to have an impact on the way data is used and on the way that privacy is treated, I think that we need to really modernize our notion around harm and around unfairness. So I would say, first of all, I hope your hypothetical is wrong. Okay, I do think that Congress needs to enact a law, and if Congress doesn't do it, I think the states need to do it. And so we can debate about preemption later on, perhaps, but we need to have baseline privacy legislation, whether enacted in the states or enacted in Congress, that is going to engender more trust, is going to bring the United States back to relevance in the conversation around how data is used, and that really looks at the data economy as it exists today. So when you think about the data economy as it exists today, and you think about the materiality, the unfairness test, one of the big problems is around harm. When I was a commissioner, was always worried, as Manisha knows, that we didn't bring enough cases that were pure unfairness cases. And the reason often was because there was debate at the very highest levels of the agency among the commissioners as to what was appropriately deemed to be harmful. So I think that actually we should take this out of the hands of the commissioners now. I think the commissioners shouldn't be debating this anymore. This is a policy question that Congress should decide, or that state legislatures should decide, because we need to see action. We need to see some guardrails put around some of this activity.
Okay, David, last word on this, and then we'll move on to the next.
Okay, but I didn't get to your real question. So I'm happy to go on, but I actually think that if there is, sorry, David, if there is no action by Congress, then I think the FTC needs to look much more broadly at harm, because otherwise, you know, you won't have any role in how data is being regulated going forward.
Real quickly, I just want to say I completely agree with what Julie said, and I want to bring up some of the things that Julie actually said while she was a commissioner, where she really was addressing issues around the lack of ability for people to have any obscurity in situations where they're participating in our economy and in our democracy. It is, in my opinion, completely untenable in the United States right now that we have victims of domestic violence who change their names to move across the country, and for less than $10, people can go to a data broker website, associate the old name and address with a new name and address, and for those victims to have to live that way. It's unconscionable for police officers to have to worry that their children's names are put on the internet, and it's completely unreasonable for judges to have their home addresses put on the website. Do we have to wait until people take action and commit violent acts because of that? Or do we get to recognize that there are concepts around harm that haven't been identified before and that need to be included? If we can't, I completely agree with Julie, the time is now for federal privacy legislation that gives more authority and resources and focus for the FTC. If we can't have that, we need to take a look and say, these actions are completely unreasonable in an environment where more data is being made available. Particularly, it's important for society to have more data for the training of AI algorithms to benefit society. And our level and ability for doing data analytics to derive things from that data and to sort that data has greatly improved.
Okay, before we, go ahead, Lydia.
Kind of one really quick comment. Julie, and David, I completely agree that the time is right for federal legislation. I can't imagine, on the panel before us where everybody just went right down the line and everybody supports this. I don't remember a time when that occurred. But Julie, one thing, I think that, I agree with you. I don't think that people in the C-suite think about unfairness and deception. They don't think about those statements, but they do worry about FTC enforcement. They really do.
No,
people
they don't.
who are responsible for
Sorry,
privacy.
They don't. Look, if the lawyers come to the CEOs and they say, okay, we're being examined by the FTC, then yes, it becomes an issue that they worry about. I do agree with that, but it's not in everyday planning about how data is used. It's not in developing products and services that people are sitting back and saying, oh gosh, what is Manisha going to say about this? That's what I mean. I'm talking about thinking about the guardrails that are put around activity before you engage in that activity. That is where the C-suites are, honestly, they're just not thinking about the U.S. restrictions.
So I completely agree that this is the time. But, day in and day out, we're counseling companies on exactly what to do before they roll out products. So, and they are concerned about what the FTC reaction will be.
And the FTC has been much more aggressive about enforcement than the European DPAs have.
I agree that the enforcement regime and the compliance regime is, I don't disagree with you, Baron. I do think that things are changing in terms of the European regulators, and I think that they are becoming more aggressive. You just look at the last, say, 6 to 8 months, and there's been a sea change there. But the tradition in the United States has been one of taking a look at activities, coming in within the radar of the FTC's sort of, enforcement regime, and then people start to pay attention.
That's a good segue to talk about what the FTC has been doing in terms of its enforcement work and what its orders have generally looked like in the privacy space. And I want to start off with David Vladeck for your general thoughts on whether the FTC is using its existing toolkit effectively in FTC enforcement actions. For example, we heard on the last panel, and we've also heard others in the hearing express the concern that the core of the FTC privacy orders, the comprehensive privacy program provision that requires an independent third-party assessment of a defendant or respondent company's privacy program is not rigorous enough, that the effect of being under order does not do enough in terms of providing public information about the company's practices. What are your thoughts on those issues, David?
So, I think there are two serious holes in the FTC's remedies. One is the lack of initial finding authority, which may be why Julie thinks that the people in the C-suite really are not worried about the FTC. If you can't find them for the first shot across the bow, that's a real problem. The other is the inability to get damages, because most of the privacy cases we bring, the FTC brings, there's no financial remedy. If there's no civil penalty, there's no remedy. The only provision for damages in the statute is in Section 19, which is rarely used. But the statute ought to authorize damages, real damages in Section 5 cases, in Section 13B cases. And so in a case like Google Buzz, where the rollout of Google revealed all sorts of personal information, the Commission should have had at least the option of seeking damages, because civil penalties are not available. That might have been a deterrence. And it's very hard to quantify any other form of any other form of damages. So in terms of, and of course, I think the agency needs notice and comment rulemaking. In terms of how the agency is using its authority, there's more it could be done, but there's a trade-off. The FTC could require admissions of liability. It traditionally does not, but if you wanted to increase the pressure on companies and get Julie and her colleagues in the C-suite worried, that would be a tool to use. There are more personal liability. The agency does not often go far down the chain in terms of personal liability. And in terms of I helped design the first reporting requirements in privacy cases, and I think the Facebook problem and others have shown that it's not sufficiently rigorous. I think there needs to be, and I haven't seen the current versions, but there needs to be greater transparency. There ought to be more frequent than every 3 years. I mean, I think the agency really ought to rethink whether the transmission belt that was designed in the first generation of these orders needs to be ramped up. LabMD, I think, is an irrelevant case because it's the only litigated data security case. No one who's ever consented to an FTC decree would have the chutzpah to say, I just didn't understand what I did. In that case, they should sue their lawyers, not the FTC. But the consequence will be, I suspect, that there will be much tighter orders going forward. The agency can write tight orders. We did this with ad substantiation. There's no reason why the FTC, if the industry says it needs more guidance, though I'm sure no respondent in any case would ever say that, but if the industry needs more guidance, the agency can provide it. So I think there are all sorts of tools the agency has to toughen up its practices. Let me just say one last thing about comprehensive privacy legislation. I think there's a lot Congress ought to do without comprehensive privacy legislation to bolster the FTC. I mean, the resource issue is just enormously overdue. Congress should have addressed it a long time ago. But, one of the concerns I have is federal legislation is essentially inevitable anyway, because you have the California law. Once another or two other states pass statutes, you're never going to have the dystopian sort of, I forget what David called, the disuniform state law, because the Dormant Commerce Clause is going to kick in. That is, at some point, when the second or third state tries to regulate companies that are doing business nationwide, they're going to sue under the Dormant Commerce Clause and win. So the question isn't whether there's going to be federal comprehensive legislation. The question is, when should it take place? And my own view is, let a couple of other states pass their statutes. Let's see what kind of experimentation there is in the states, because ultimately, at some point, the Dormant Commerce Clause will force some sort of uniform national law.
Responses or reactions, especially to what David said about the remedies issue in particular. Barron?
Yeah, I'm looking forward to David joining us as an amicus in our challenge to those state laws. I'm not so confident it's going to work out so easily. And by the way, the term patchwork is the wrong metaphor, because a patchwork is, every state has their own laws for inside their state, which is what happens for data breach notification. What we're talking about for privacy is every state regulating everyone. That's not a patchwork. It's an enormous pile of many, many layers of regulation. So it's even more of a problem. Anyway, but getting back to the question of remedies, look, there's a lot going on here. First of all, it's a problem whenever we start saying that appellate court decisions are irrelevant. They're not irrelevant. They constrain the agency. And in particular, the specific clause that was at issue in the proposed remedy that the FTC was seeking was the same one that the FTC imposes in all its privacy and all its data security cases, requiring a comprehensive program to have reasonable data security or reasonable privacy in privacy cases. And the 11th Circuit said you have to have specificity in your order. Now, maybe the FTC can do that, right? But that's a real change they're going to have to make in how they handle these orders. But that's only one.
But that's a litigated order. It's not a consent order.
I know. But David, the point is that, sometimes people actually might want to litigate, and maybe we're not just going to have another 20 years of 200 cases not getting litigated. Maybe we'd all agree that it would be a good thing if the line in the unfairness policy statement by which the FTC promised that it was going to be the courts and not the commission that was setting the boundaries of the law was actually taken seriously. Now, I'm not blaming the FTC for that, right? But there are all sorts of reasons why all these cases just settle. And primarily, it's because privacy is so darn sensitive, because contrary to what Julie was saying, people really do care about their company being put in the crosshairs and being on the front page of the newspaper, right? That's why these cases settle fundamentally. We can talk more about that. But this remedies issue is a really important set of problems. So on the one hand, David says, well, we should have monetary remedies even though we can't measure the harms that are being inflicted in privacy cases. Well, if you can't do that, I'm not sure how you calculate what the remedy is. And then you're talking about civil penalties. Okay, so if you want to have a conversation about civil penalties, I'm willing to have that. But when you do that, you have to understand, first of all, why the FTC Act today does not include civil penalties for first-time violations. And the answer is very simple. You cannot marry an incredibly broad law that is incredibly vague with the ability to impose penalties upon a company that simply fails to predict where a line is drawn. Right? That is bad policy, and it may be unconstitutional. What is appropriate and constitutional is when companies have notice of what is unlawful, where the violation is so extreme as it is in fraud cases. That's a kind of deception case today. In those cases, yeah, sure, it's appropriate to go after civil penalties. But our guiding star in thinking about penalties should be, does the regulated party have notice? And where they do, that's appropriate. Just one more thing about penalties. The FTC's now lost a series of cases, right? And this is now going before the Ninth Circuit. If you're not following this, right, there's a Shire case is about the injunctive order part of this, but Kokesh, I've written about this, is about whether monetary remedies under statutes like 13B are in fact penalties. And the Supreme Court in Kokesh, in a case not involving the FTC, said yes, they are. And this is now, this is just a second, this is now before the Ninth Circuit. And if the Ninth Circuit says that the FTC can't get like monetary remedies like disgorgement and restitution under 13B, that's going to be a real problem for the agency in cases where everyone thinks they should be able to get that money, like in hardcore fraud cases. That's going to require legislative action immediately. It's going to be far more urgent. Maybe it'll push some of these things over the goalpost, but we cannot simply dismiss these appellate court cases as irrelevant.
So
let me just
David, did you have something very quickly, and then I want to go to Julie and Justin.
From Kokesh, because Kokesh is actually quite clear in distinguishing between compensatory disgorgement and non-compensatory disgorgement. The court says a pecuniary sanction operates as a penalty only if it is sought for the purpose of punishment and to deter others from offending in like manner, as opposed to compensating a victim for loss. So the Supreme Court quite clearly—
It's not clear, David. There's other language in that decision that suggests that if it's not done by statute for the sole purpose of compensation, it's at least in part a penalty.
No, so there are now—
to litigate this case.
There are nine—
The Ninth Circuit may resolve this for us.
You know, they both have 10-page papers addressing their arguments that we can point people to.
There are nine cases so far.
I actually was going to suggest that maybe we are developing a theme of issues that panelists need to go discuss over drinks, but Julie wanted to—
I hope this won't be the same thing. Just, Barron, I agree with you and disagree with you. So just to be really clear about what I was saying, I think people care about the FTC when especially the FTC comes calling. Nobody wants to be the subject of an FTC investigation. I think the standards right now are so vague, unfairness, deception, that it's really hard to action them. In contrast, when you look at other privacy laws around the world, they are deeply progressive. They have deep relevance to how operations take place within companies. And these laws force the C-suites to be thinking operationally ahead of time about how they're approaching data use. It's just a completely different way of thinking about regulating data. So yes, of course people care about the FTC, but how many times is the FTC going to come calling any one particular place? So that's one thing in terms of that issue. But I do agree with you, Barron, that in some ways we need more definition. And I personally believe that it should not be the courts. I think that Bill Kovacic makes a great point when it comes to the competition issues, that sometimes when you leave this just to the courts get pretty conservative, especially if you throw in a private right of action or treble damages. They'll get really conservative, and that may be one of the reasons why we're in the state that we're in with the competition laws. I would much rather have policymakers set policy. And the policy here that needs to be set for all the commissioners so that Manisha can with confidence go forward with an unfairness case, which I want her to do more than anything else in the world and have for the past 10 years, is to say, give her a little bit more meat so that when she meets with each of the commissioners, she can say, well, this is what Congress has said is unfair. You guys don't need to debate it anymore. Reputational harm is unfair, just as one example. So I do agree that there needs to be more definition, but I think that it should be Congress that makes that definition, or state legislators make that definition, and then the states and the state AGs will decide these
and
things.
to give Manisha the resources so that she can fight that litigation.
We're going to talk about resources in a minute, because I have a whole bunch of things to say about resources.
I don't disagree with you, Julie.
But first, actually, Justin had wanted to weigh in. Maybe the moment is gone.
Briefly. One, I remain skeptical that privacy programs and assessments are ever going to be super meaningful. So I think reforming that process is I don't think you're going to get the benefits from that. I think there are strict liability costs of having a privacy order against you. Having talked to a lot of the companies who have them, I don't think they meaningfully change their behaviors. I think doing more fencing in, again, maybe leaning into your unfairness authority, both making more aggressive claims and complaints, but also an order saying in order to comply with the law, you need to do X, Y, and Z. Again, I think it's not a substitute for a privacy bill, but I think there's to be more aggressive in negotiating for fencing in relief in orders. Setting aside the law around disgorgement, I'm not sure what the FTC's policy is. I mean, I think there should be more. I think, as a matter of course, they should try and ask for in more cases to get disgorgement of ill-gotten gains. We filed comments on the Patriot Plug case as one example of a place where they probably should have gotten disgorgement of ill-gotten gains. At the very least, articulate and enforce a policy, because right now I think there's not a lot of clarity around that. And finally, just want to echo David's point around personal liability in more cases, I think would be a deterrent behavior.
Okay, thank you, Justin. We're going to move on to the next segment, which I think everybody's alluded to and everybody really wants to get to, which is what additional tools do we need? And if we need legislation, what should that legislation look like? So again, I wanted to divide this discussion in two parts. The first, I want to talk about tools. And second, I want to talk about what the substantive requirements of legislation should be, all in 20 minutes. I know we could do a whole panel on that second one, but let's just hit the highlights for this 20 minutes. So first, in terms of tools, David has already talked about civil penalty authority. I just want to touch on two additional things. One is I want to ask if the FTC, if you believe the FTC needs more resources, and regardless of whether the FTC needs more resources, what are the areas we should be focusing on? And second, should the FTC have APA rulemaking authority? Because that has been controversial in the past, and I wondered what people's thoughts on that were now. So maybe I could start with Justin on those questions.
Yeah, on staff, I'm fairly confident you'll have universal agreement up here. The FTC needs a ton more staff. Chairman Leibowitz pointed out they're about half the size they were in the 80s. The economy and population has grown tremendously in that time. Meanwhile, other agencies like the FCC have kind of dumped their responsibilities on the FTC, saying, we're not really interested in this anymore, y'all take care of it. I think it's really a mixture of both lawyers and technologists. Especially there are a lot of the libertarian folks who are arguing you need to litigate more cases. Litigation is really labor intensive, and so I think even under the existing consent order model, you would need increase their staff tenfold. If you're going to make them litigate every case, you need to increase it 100-fold. Also, I think you absolutely need more technologists at the agency. I think this has been a recurrent theme that you've heard from a lot of folks over the years. A little bit disappointed that there has not been a chief technologist appointed to guide the agency during this time. My group, OTEC, when I joined the FTC a couple of years ago to help kind of bring more technical expertise to the Federal Trade Commission, never got higher than more than 10 people. Now I think down to maybe 5. And so again, getting it up to 10 is not going to solve all the problems. They need, again, orders of magnitude more. But again, there are FTEs out there that should be filled to help do the best they can right now. Just quickly on APA rulemaking, I think, in general, I think they should have discretion and authority. I don't think they should be directed to issue regulations, but especially if people are concerned around fair notice, the best way to give people fair notice is to have more precise rules around evolving issues. So I think it absolutely makes sense to give the FTC rulemaking authority around privacy.
Okay, anybody else want to chime in on those?
I'd love to chime in on resources, and I understand that everybody says you need more resources, but I think it's important to sort of look at this in a global context of what is happening again around the world. Chairman Simon recently said that, Manisha, you have 40 people on your team. I can't believe what you're able to do with 40 people. You are definitely like the proverbial wizard behind the screen. Don't look at the man behind the screen in The Wizard of Oz. You are amazing with what you can do, but I want to put it in context of what's going on around the world. So that means that with 40 people and a population of 329 million, that there's one employee on your team per 8.2 million Americans. Okay, so let's keep that in mind, 8.2 million Americans. The Irish, which have become the lead data protection authority for many companies in Europe and are a very significant regulator, have 180 employees, a population of 5 million, which gives them one employee for 28,000 citizens. Now, again, they have a global responsibility, but obviously so do you, given all the companies that are here. So 1 per 8 million in the United States versus 1 per 23,000 in Ireland. Let's add in the UK. We're not exactly sure where the UK is going to wind up, whether it's going to be in Europe or not in Europe, but still, they have 65 million people in the UK, 180 employees, and that means, 700 employees, 1 per 93,000 British citizens. I mean, these numbers just are remarkable when you put in context the resources that you have. And when I think about resources, I completely agree with Justin. It should be lawyers, it should be technologists, it needs to be economists. I think that these teams really need to work together. I think you need litigators and you need people who are sort of subject matter experts. It needs to be sort of a robust team. But the notion that the FTC, as the sole regulator here in the United States, is governing, thousands and thousands of companies that are affecting not just people in the United States but also globally, and you're the lead regulator with 40 people, it's remarkable. And then the other thing that happens in Europe that does not happen in the United States, I think most people here are aware, but actually the European data protection regulators are required to work together when there is a cross-jurisdictional issue. By statute, by the regulation, they're required to work together, which means they get to augment their resources with each other. There's no requirement here that the state AGs have to work with Manisha's team, or that Manisha has to work with any particular state AG. And sometimes they do and sometimes they don't. So we can't, when I have conversations on the Hill with senators and representatives and their staffs, they look at me and they say, well, those are really interesting numbers, but what about all the state AGs? And I say, well, there's no requirement that they work together. So you can't really lump them all together. So the resource question is just out of control. And I just hope, whether there's legislation enacted or not, I really hope in some budget context or otherwise that this is taken care of.
Anybody disagree with anything that's been said?
I don't disagree, but I have one thing to add, which is I just think we shouldn't lose sight of the tremendous responsibility that the FTC should have on educating people and the resource requirement that would be required for that. Too often we say the privacy regulators should just be focused on enforcement. Individuals could really use a lot of education in this country about how data is being used to harm them.
The 40 doesn't count the people in the consumer ed.
There's a big team.
There is. Just to clarify, I disagree with, I agree with your fundamental point, absolutely.
Okay, Lydia and Barron, and then we'll move on.
I actually want to raise a question. Folks have talked about APA rulemaking authority across the board, and I think in this area, I don't know if the FTC got across the board APA rulemaking authority and then and then adopted a privacy rule, whether it would address one of the real challenges, which is preemption. I think that needs, I'm kind of raising that as a question because the FTC has never had across-the-board APA rulemaking authority, but I don't know that it could issue a preemptive rule on its own.
Yeah, and I think I was really asking in the context of legislation. So assuming specific privacy legislation was passed, should we have APA rulemaking authority? Barron, I'll give you the last word on this. And we'll move on.
Yes to more resources, especially for technologists. On the question of rulemaking, as with civil penalties, it's not a binary. The question isn't whether the FTC should have more rulemaking. Congress has always passed statutes that give the FTC rulemaking authority. But that's the right way to do it, to focus the grant of rulemaking authority on a clear set of problems. What I have a problem with is marrying rulemaking authority with an incredibly broad standard, like unfairness. Right? That becomes then a blank check by which the FTC becomes, as it was in the 1970s, the second national legislature. Let's remember, it was not some sort of libertarian crackpot Reaganite band that tied the FTC's hands on rulemaking. It was a Democratic Congress in the Carter administration, okay? And for good reasons. So rulemaking, like civil penalties, needs to focus on clear, specific problems. And once you have those safeguards in place and the FTC has a lane to work within, sure.
Okay, so now let's move on to kind of substantive requirements of legislation. And on the last panel, I did a thing where I asked people to raise hands, and I'm going to ask people to do that again. Maybe I should have quit while I'm ahead, but I'll do it anyway. So throughout the 2 days, we've heard about potential goals for privacy policy making and privacy legislation. And we, I think there are 4 of them. And please feel free to add if you think this is not kind of, if this doesn't encompass the goals. Thank you. The first is preventing harm. And you can raise your hand for more than one. I'll go through them first. Preventing harm, improving transparency and consumer control, avoiding surprises, complying with consumers' expectations, and finally, promoting competition and technology and the benefits of technology. Okay, so how many people on the panel agree that preventing harm is one of the goals of privacy policy making?
With the primary goal,
one of the goals.
So we can vote for all of these if
you can vote for all of them.
Okay.
Okay, yes, okay. Improving transparency and control. Okay. Avoiding surprises, comporting with consumers' expectations. Okay, and promoting competition and ensuring the benefits of, okay. Wait, did somebody?
Sure,
okay, so, okay.
But I don't think that's everything.
Okay, please, what is missing from that list?
Accountability. I think that you need to instill accountability in companies. I think that focusing solely, and I'm not saying that you've left it out necessarily, but I think it needs to be called out specifically that we need to move away from sort of a notice and choice regime where everything is placed on consumers and they have to make every decision with every website or every IoT device that they use. And instead, I think in addition, I think we need to also add in corporate accountability.
Can I just follow up with that? Okay, so let's, can you kind of give us any ideas of how that could be included in legislation? So we know that in GDPR, there's a DPO that's required, there's risk assessments that are required, and there's kind of a regime built around that. Yep. And we've heard, again, that may be one thing for companies like Microsoft, but how do you legislate it for a broad range of companies, a broad range of sizes, and it's not sizes, it's how much personal data they collect.
Right. Well, it's also, so there are things like requiring some kind of person in the company to be responsible for this is a good idea, but I don't think it's necessary. I think the risk assessments are really the key. And risk assessments, like having to surface an individual's data, having to give them access to their data or allowing them to delete their data, these two things coupled together, the data subject rights plus risk assessments, do a tremendous amount for data hygiene. If you have to surface data for an individual, you have to know where it is. And you have to be, you have to either tag it or figure out you don't need it anymore, you're going to delete it. It promotes data minimization. It promotes all sorts of great data hygiene. Similarly, risk assessments require companies to take a look at what they're doing and to explain to themselves first, is this okay?
So
but in terms of the size of the company, I just want to say one thing real quick. Cambridge Analytica had 100 employees. It was a small company. The issue should not be about the size of the company. The issue needs to be about the type of data, as you pointed out, but also the agility of the company. What we find, we have millions of customers, all different sizes. We find that the smallest companies actually in many ways have the easiest time with some of these new global laws because they get to build to them. They are agile. It's new. They say, okay, this is what our standard is. It's the mid-sized companies that have legacy systems that have been around for a couple of decades. They have the hardest time.
So this is interesting, and Justin, I want to kind of raise this with you because several panelists on this panel and the last panel have raised concerns about the privacy assessments in our orders. Those are risk assessments. And so if we think they're effective in the context of GDPR and not effective in the context of FTC orders, is there a disconnect there? Is that, and Justin, you don't have to answer that question. You can answer what you were answering.
Answer this question. No, I think risk assessments are not. When substantive protections in a bill are tied to risk assessments, I think that's really bad for both consumers and for small businesses. So you've seen a fair number of bills out there that say you have the right to delete your data if the company conducts a risk assessment and says you have a privacy risk, or you have a right to opt out of processing or sharing if they do a risk assessment and there's privacy risk and it's not outweighed by their compelling interests. I think those sorts of bills that pair high levels of process are good for big companies and for law firms, but they're bad for consumers and small businesses because they don't have clear obligations or even very strong rights. And so I'm definitely concerned by, if that's what you mean by accountability, then I think I strongly disagree. If you mean like the classical notion of accountability, which means you get in trouble when you break the law, then no, that I'm not in favor of.
No, what I'm talking about, what undergirds the risk assessments will be unfairness and deception unless you decide to create a different standard. And there are discussions around creating a duty of care, a duty of confidentiality, a duty of loyalty. That's one concept. Other concepts, there are other concepts out there about what you would build to undergird the risk assessments. Clearly, there has to be something that you're assessing, right? There has to be something that you're looking at. So it's not sort of free-founded. In terms of small companies being able to comply, listen, that happens to be what Microsoft does, is we provide these tools to small companies. We provide them to medium-sized companies, and we provide them to very, very large companies. I think the idea that this is hard should not be a reason for not going forward. We still need to go forward, and we need to get small companies, medium-sized companies, and large companies to understand that data is really important and that they need to protect it.
Okay, so I think you've kind of responded to my next question, but I'm going to ask the rest of the panelists, which is, if you could name one thing that you think that U.S. federal privacy law should take from GDPR or CCPA, and one thing that U.S. privacy law should avoid from GDPR or CCPA, what should they be? And I didn't tell you I was going to ask that question, so I'll give you a minute to think about it. It doesn't have to be one thing. What do you,
Well, I've got one thing that should be avoided from CCPA, but go ahead.
Yeah, I think the one thing that I would take from the GDPR is the notion that privacy is a right. I mean, the only right of privacy that Americans really have is the Fourth Amendment, which is a right of privacy against the government. The statutes that we have do not create, are not by and large rights creating as we use that term. And so one thing I would hope that if there is federal legislation, we talk in terms of rights creation. The other thing I'd mention is we need to deal with data brokers. So when you're talking about privacy legislation, that has to be on the table.
David?
Yeah, just to follow up on that, because it's right in line with David's last comment, the first thing I think we need to take from GDPR is it's got to apply to all personal data. There can't be a carve-out for publicly available data or government records, because that's the data that the data brokers often are using. And I think we need to avoid this over-reliance on consent and control that you see in CCPA. Individuals just don't really have that. That's a false promise.
I'm sorry.
Lydia?
Yeah, so what I would definitely avoid is the failure to really be clear about what is personal information, what information is covered. I think that, I think the GDPR tries to do that but there are real questions about, what is it to pseudonymize data, and I think that the CCPA is incomprehensible on that issue. And I think, what I would take from both of them is, I think as David was mentioning, kind of the notion of consumer rights, the right to access your information, the right to delete it, the, right to see what is being held about you.
Okay. Barron?
I would definitely avoid the GDPR's failure to give any incentive to de-identify data, to, the way in which the law treats all data essentially equally. That's insane. You asked us earlier what should be the FTC's goals here, and I would add that one of them should be promoting pro-privacy innovation. And a big part of that means making sure people have an incentive to treat data appropriately. The Bureau of Technology that I hope will be created here could be a leader in actually actively helping that someday. So I would avoid that. One thing I would take, I think that the CCPA is exactly right in preempting municipalities, and for exactly the same reason that we should preempt states. And preempting doesn't mean taking away the ability to enforce laws. Go back and look at the Obama 2015 proposal. I think that was a very reasonable proposal for having a single federal framework in which, state AGs would have a role in enforcement and there would be coordination, but you wouldn't have a situation where the states made their own laws. You would look to the federal law.
Justin?
So I think I would agree with the last panel that I think data minimization or focused data collection kind of tied to the context of the interaction is the most important element of it. You buy something online, they have to take your credit card information, they have to collect some information. They shouldn't have to get a separate consent. Yes, I agree to this. There should be some reasonable carved out first party secondary uses, and I think like the original iteration of the FTC privacy report with the commonly accepted practices is probably a pretty good place to start with that. But then the idea about your information is going to be sold to data brokers, I think by default we should expect that that actually wouldn't happen. The idea I would not want to transport from GDPR is the idea of legitimate interest, which I think can end up trumping any privacy rights or obligations that if it's interesting to you, then which is obviously an overstatement of what it does, but it's not too much of an overstatement. So I do not want to see that concept incorporated into U.S. privacy law.
Okay, so we are reaching the end of our time. We want to give everybody 30 seconds or so to wrap up, and I will leave it to David Vladeck and Barron to decide whether they want to use that time to revisit where I had interrupted them previously.
No, let me just sort of, I guess I have two comments. One is, I think the FTC has done a terrific job given the resources it has. But the root problem, I think, remains the lack of, significant enough resources to do a comprehensive job. When I was bureau director, I thought I was really simply a triage nurse trying to figure out which fire was the most important one to put out. And I suspect others have had the same feeling. So, until the FTC gets the resources that are actually adequate to its job, there are going to be concerns. And so I think, to me, the most pressing issue is resources. It's one that's been pressing since 1983, but it needs to get solved.
I agree with everything David just said.
So we can end.
For me, the big issue here is providing notice proportionate to penalties. We're always going to face the same problem the FTC's always faced under unfairness, which is that there are too many practices to anticipate with specific prescriptive rules. We're always going to be relying on a vague standard. Maybe it's not going to be unfairness and deception. Maybe it's going to be risk and context or duty of care or fiduciary duty or whatever you might call it. But in those scenarios, you've got to have a scenario and understanding that you can't penalize companies for not anticipating where a line is drawn as a general matter, right? You can deal with process concerns, but the first relief is going to be injunctive, and you can hold people responsible once a violation is clearly established.
Okay, so I totally support more resources. The FTC should definitely seek them, and Congress should absolutely give the agency more resources for privacy in particular. I think that the agency needs to have a voice as federal legislation is being considered. I know that the FTC often kind of listens and reacts on when federal legislation is being considered. But I would hope that that out of these hearings certainly come some recommendations, and even before a report is written, that folks here sit down and talk to people on the Hill and have an opinion about what legislation, what form it should take.
Yeah, I echo that. The FTC should be calling for a comprehensive federal privacy legislation that gives them more resources, gives individuals more rights, and more authority for robust, harmonized, and predictable enforcement. Intel wrote a draft that we posted to a website at usprivacybill.intel.com to try to keep that conversation going around a bill that could look like that. We need to get down to the specifics of talking about language that can link together. These issues are hard when you get to the point of actually trying to put language in place. Let's get to that point and start talking about what the bill should look like.
Yeah, so I agree with other panelists. FTC, I think, has done a strong job with their limitations that they have. I think there's more they could incrementally do, but I think fundamentally they need new law and new resources, and I think they should be more explicit about that. I think the FTC, and we've debated this when I was at the FTC, that we should say, we can't do this without more. I understand the desire to kind of convey, hey, we're good, we got this, we're doing a strong enough job, but you can't. And I think it needs to be explicit to the world that in order to do the job that needs to be done, you need more.
And I would just, I definitely agree. The FTC needs more resources, both in terms of actual dollars and people, but also in terms of better laws that are more fit to purpose. And I really think the U.S. needs to take a step back and recognize that we're really not fit to purpose right now in terms of the modern data ecosystem. We need to recognize that consumers have lost trust, and we need to rebuild that trust. And I'm talking about consumers in the United States and consumers around the world who are really asking a lot of questions. We need to answer those questions, and part of that answer is going to be the FTC is the right agency, but it needs many more resources. And we need to start thinking about what the world is going to look like, not just in a few months, but in 5 years and 10 years. And we need to lengthen our horizon in terms of building that trust.
Okay, thank you to all the panelists. We're at the end of our time, so please join me in giving the panelists a big round of applause. And if you guys could just stay up here for 2 more minutes. You could stay here for 2 minutes. I'm just going to wrap up the day just with a couple of observations. So first, there's a lot we didn't get to today, and so I would encourage everybody to take advantage of the comment period. Public comment period will remain open until May 31st. We would encourage submissions on anything that you've heard over the last 2 days, and in particular, any empirical research or data that you can provide to us would be really helpful. So I just want to kind of wrap up with just a couple of observations. One of the things I started thinking about as we kind of went through these last 2 days is kind of what is new. We've done this rodeo before, and we've done this. We've done privacy hearings many years ago. I see many people who worked on them in the audience. So what has been new really over the last 10 years? And I think there's really a lot of new things that have taken place over the last 10 years. We have new laws. We've talked a lot about GDPR and CCPA and other new state proposals. We haven't even had a chance to talk about laws like PIPEDA and other laws that are non-Europe, non-US, but there's a lot of new laws out there. There's new technologies. We talked about IoT. We talk about kind of home assistants generating lots of data, big data, artificial intelligence, machine learning, connected cars, that whole gamut of issues. The idea that there's a lot of passive collection from sensors, that there's a lot of inferred data about people. So these are kind of some of the new technologies and business models that are out there, and we've heard some new concerns. We hadn't heard the phrase dark patterns even a couple of years ago. We hadn't heard the phrase algorithmic discrimination 10 years ago, and that's something that I know a lot of people are focused on now. So with all of these new concerns and new technologies, was there any consensus over the last 2 days? And so let me just kind of float 3 areas of consensus that I heard over the last 2 days. The first is the consensus on the goals. So consensus on the goals of privacy protection. We've talked about protection from harm beyond financial harm. We've talked about transparency and choice. We've talked about, but not as the sole goal. We've talked about transparency and choice as a goal. We've talked about the need to promote competition and innovation in this space. So there's a lot of consensus around the goals. There also seemed to be a second area of consensus, which is consensus towards the fact that there should be federal legislation. And we've seen a lot of proposals for federal legislation, and we've heard a lot about them over the last couple of days from entities as diverse as the Chamber of Commerce, CDT, Apple, Intel, World Privacy Forum, the coalition of companies and trade associations that Stu Ingus talked about. And then the final area of consensus is that it does seem that there's consensus that the FTC needs new tools and resources. I even heard the representative from the Chamber of Commerce earlier say that Section 5 is not enough. So I think those are the kind of very high-level points of consensus. I think the hard work is yet to be done to drill down on what some of these proposals should look like. But let me just close by thanking all of you who stuck it out till the end, all the audience members, the 50-plus panelists, all the public commenters. I'd like to thank some particular offices that helped us here: Office of Policy Planning, Bureau of Consumer Protection, Office of the Executive Director, and Office of Public Affairs. And mostly, I would like to thank the three team members who were completely responsible for all of the heavy lifting on this event, and that's Jim Trilling, Jared Ho, and Elisa Gilson. So if you could give all these folks a round of applause. And again, thank you very much for coming, and we look forward to seeing your comments. Thank you to the panelists.